May I please your lordship, I beg to mention with the consent of others, right?
She's mentioning, my lord.
No, no.
I'm for the petitioner, my lord. They want to sign it, my lord.
With the consent of others, I beg to mention 5, 6, 7, 8, and 14. My senior is out of state. The kindly matter may be taken after 2 weeks.
My lord,
After 4 weeks.
After 2 weeks, lordship.
Well, it may be fixed on 6th or 7th, my lord.
6 or 7, are you okay with 6
Yes.
or 7?
Yes, right.
A prayer for adjournment has been made. Yeah. Yes. Standing on PSP.
Yes, lordship.
Region Saharan Council present presentation has agreed to by the parties. This on
6th or 7th, any day. Mark.
5, 6, 7, and 14.
Yes, lordship.
No, 5,
Eight,
5, 6, 8.
8, 5, 6, 5, 7, 8,
6, 7 also.
is 14 connected?
What not connected, my lord?
May I please your lordship? Lordship, I beg to mention for listing of 2 matters for admission, lordship.
Matters of which year?
23, lordship.
Why are you mentioning?
Lordship, the award given by the civil court, lordship, against land acquisition and Virat, that was paid by this honorable court, lordship. And I'm for the respondent, lordship.
You are for the respondent.
Lord.
Have you filed any IA for application?
No, lord.
Have you filed the affidavit? No.
No, lordship.
Then why don't you file the affidavit first? File the affidavit and make a mention.
Obvious, lordship.
Or file an IA for vacation of the interim order.
Beg to mention to read petitions for admission. These are matters regarding illegal mutation on the land.
Illegal mutation.
Yes, ma'am.
Matters of which year?
One is 22, one is 23.
When was it last listed?
The one of 23 was last posted in March.
And the other one?
The one was September.
Both pertaining to same subject matter?
Yes.
Okay. We'll have it next. Give a date for next week. Don't give a hearing date. And give next Wednesday. Yes.
May
Yes,
please
Mr. Das, yes.
we have filed this IA on 22/8/2023 laws. It's connected with
IA for?
It's connected with as a disposed matter also MSAPL 626 of 2017 law. It has been disposed in a low adalat in the year 2020 laws. 12/12/2020. Certain omissions are there in the order laws because of which the claimants are not able to withdraw the money before the registry laws. That is required
Can I reopen anything?
No, we are filing this petition. We have filed this petition under section 150 and 152 laws, seeking correction of omission in the order law.
What kind of omission was?
Lordship, the total amount which has been settled in the local lot was 12 lakhs. Insurance company inadvertently submitted that 7,19,000 has already been paid to the claimants. In fact, that amount is still lying in the registry laws. So, because of that observation,
we'll have when
as per the convenience of papers.
Monday is the holiday on Wednesday.
Lordship.
Lord, item 12. I am for respondent number 5. We have filed an additional affidavit for that. That will be.
You have filed it?
Yes,
today? Have you served with the
Yes, we have served it.
May it please your lordship, I beg to mention item 4. Lordship, I am appearing on behalf of SP Das. He could not appear today as he went to Hajo. Lordship, I may not take this matter as your lordship had appeared for the petitioner in this case.
Good.
It may be listed in another court.
Please for any other bench or
May I please to Lordship, I beg to mention a repetition for admission.
petition of which year? Case of which year?
2020
22. What is the subject matter?
non-payment of outstanding revised rent acquisition compensation in terms of arbitrator.
Okay, next Friday. Not tomorrow, next Friday.
In this case, I am assisted by Rajiv Borpujari. He is in bereave and his mother passed away. So I am praying for listing of this case on 4th of December.
Where is the water court? Yeah, where?
Uh,
What is the subject?
that's why I did not
What is the
mention.
subject matter?
It is regarding Pirola Fatra Lordship that judgment Lordship has delivered.
Yes.
Now the tenants have come or the riotees have come. Lordship has dealt with the matter when the owners or title holders came before this honorable court.
Yes.
Lordship passed the order in favor of the state.
Right,
They
right.
went to the division bench. There is no stay, nothing. Now the riotees have come.
Non-APS petition are not called. There are three. Please take care of it. ATS now. However, submit that should appear for it and will be accepted by our board project who is under bereavement of that under therefore the fact matter is adjourned. Will sit for motion on
4th of December. That's a Monday.
court.
Highly obliged. Sir.
Mr. Sharma, which matter?
I for just and proper decision on this case. I wanted to assist you as an inventor. As because this
Item number?
9, my lord, with my line.
You filed an interpreter petition with consider.
That is a Satra land.
No, no, you filed an interpreter application with consider.
In this case, the report we have gone through, they have filed an affidavit also. So I'd like to need some more time to go through all the papers. So could it be
You
an
have filed
option?
affidavit today.
Yesterday.
Yesterday.
Is it on record?
Yes, it has come, I believe.
Yes.
It can be taken on 30th of this month.
30th.
Yes. 30th.
30th.
Thursday.
30th, no. Full bench is on.
Then let it be on 4th of
No, no,
December.
no. It's 30th, there is no full bench. Full bench is on a Tuesday. We have fixed on 5th.
4th of December.
30th.
30th, Lord.
30th.
Okay. This court has been apprised that the petitioners have filed an affidavit on 22/11/2020 after furnishing of a copy of the report of the Advocate Commission. Three, A.C. Borgora Leonard Senior Counsel present for the petition. Three, D.C.K. Leonard Advocate General Assam, however, submit that he would require some more time to examine it and has paid for listing of this matter on any other date. What about the private respondent?
Lordship, I'm appealing 4th
Three,
because I cannot object.
item number
10.
three, urges the counsel present for the private respondent has agreed to by the parties this for Will be motion only.
Motion.
Is for motion on
30th.
on 30th.
30th.
30, 11.
Safety applies.
Lordship, in item 9, Lordship. In item 9, Lordship, we have engaged senior advocate, learned senior advocate D dash Lordship. So, Lordship,
No, we are fixed on port.
Lordship,
And none appears to play.
there's an interim Lordship.
None appears to play. Where into there?
Lordship, I have actually I went to call.
None appears to play. Is there any interim mode?
Yes,
Yes,
Lord.
no courtship action, so it can be continued till
Okay,
court.
interim order passed. Let it continue to the next.
I'm Zay Abbas Lordship. Oblastment.
We are not recording your presence. We are just removing none appeared.
Lordship. Oblastment.
Here in this case, Your Lordship, we had filed our affidavit on behalf of NF Railway, Your Lordship. An affidavit which has been filed, Your Lordship, in the paragraph 7 by the NF Railway, whereby so-called notice was been issued as part of judgment passed by the trial court. Accordingly, they have been participated in the so-called notice reply has already been given. Now, after filing of this so-called notice reply, they ought to be participating in the trial proceeding by state officer. Rather, they have approached before this honorable court. Due to pendency of this honorable court's order,
Yes, Mrs. Sinha.
My lord, this is happening, my lord, the same plot of land, my lord.
No, if the liberty was granted in the earlier round of litigation by this court to go ahead with the proceedings where you have filed your reply to the so-called notice, before completion of the proceeding, how can you come to the court again?
Because the one thing is, my lord, earlier, my lord, the same plot of land, my lord. The same plot, earlier is the name, plot number 1, my lord. They filed ejection notice to us. We approached before the district judge, my lord. A district judge by passed his judgment order in favor of us, my lord.
same cause of action, Your
Same cause of action, my lord.
order by the another.
one.
Participate by my learned senior, my learned friend also participate. Same cause of
Same cause of action, my lord. It is page 23, my lord.
So what about this order? Sentence for will it cover?
yes, spell it covered.
And when
Spell it
dispose
covered,
this of,
nothing left.
will dispose this of
Yes, my
the BP Senate count for the petition. Also heard Dr. P. N. Gogoi, Senate Standing Council, Railways.
Lord.
Considered that matter is pending since the year 2015 and of the fact that the railways have filed necessary affidavit, this case taken up for disposal. The petitioner, please have the petitioner came in possession of a plot of land by construct a house and running a business it claimed that in the year 1973, the railway authority had given him a receipt for the same plot of land which was numbered as 1. However, on 10/9/1990, the state officer, NF Railway Lamping, had issued a notice of eviction. The state notice of eviction was subject matter of an appeal referred for the learned district judge, Karimganj, in meet appeal number 3 of 1990, and by judgment date 3/1990, the notice set aside. The case of the petitioner is that the aforesaid lot was renumbered as 27, and whereafter another eviction notice was issued on 1/9/2004, followed by orders of eviction. The petitioner had again filed an appeal for learned Justice Karimganj, being his appeal number 1 of 2004. Full stop. The learned district judge, however, by judgment dated 24/3/2009, had directed disposal of the entire proceeding within 4 weeks. Full. The the railways thereafter had approached this court by filing a number of writs against similarly situated matters. The learned counsel for the petitioner is submits that those writs were dismissed for default and no steps were taken for its restoration. However, on another eviction notice was issued in respect of the state land, followed by an order of eviction on 24/8/2015. The aforesaid order is the subject matter of challenge in present petition. Full stop. That 3. The learned counsel for the petition has submitted that the issue of eviction was raised earlier and has been conclusively decided by the appellate court, and therefore subsequent orders of eviction is barred in law. He accordingly submits that the proceeding initiated by the impugned order be set aside. Per contrast from Dr. Gogoi, the learned standing counsel, Railways, while denying the projection made by the petitioner on fact, has submitted that there is an independent cause of action in issuing the present eviction notice and in initiating the present eviction notice, and without the same being adjudicated properly, the petitioner is trying to preempt the matter by approaching this court. Dr. Ahmed has also placed court an order dated 8/8/2020 passed by this court, WP 8/1/2016, by submitting that the facts of the state case are identical. It is this court has been informed that the aforesaid writ was disposed of by direct disposed of without interfering on marriage, semicolon, and then comma. However, making an observation that the state officer of the railways would pass necessary orders by observing all the formalities under public premises within bracket eviction of unauthorized occupants bracket Post Act 1971. That after hearing parties and also considering the order dated 8/8/2020, which has been passed on identical situation of the present disposed of by direct registered officer of the railways to consider the matter and pass appropriate orders by following the procedure based on in aforesaid Act of 1970 to facilitate such consideration of the interim order. Pass is okay.
I'm deeply aware.
Inspector. Is matter is inspector, sir.
Yes, my lord.
The DP concept for the petition submission led by effect of time from the subject matter of the has come in progress. That also heard myself Forum and then consequence who endorses the state of the is as in progress.
Deeply obliged, my lord. My lord, in this matter, I am appearing on behalf of the resident for respondent number 2.
None appears for the petitioner on call, whereas Ms. Musa had done at council discussion for the
Respondent number 2.
respond number 2 to compare the matter of and is listed under the column of the needed in the interest of the a short adjournment grant to enable the person to represent himself. Compare this on the 28th.
Obliged.
So which however may in case of further non by this court may pass the order in accordance.
Obliged. For the time being, I'm calling my senior.
Some disturbance by the ward commissioner. Yes, what?
Board commissioner.
Yes.
First of all, I tried to contact, we have spoken over telephone to the municipal board, but they think that they are not interested. You're supposed to send some instruction.
But the ward commissioner does not have any jurisdiction.
Board commissioner, lordship will pass out. Because the permission was granted by the board.
If you can raise objections to accordance with law,
Well,
not by a ward commission.
Right.
If he has some any grievance, he can raise it to the appropriate authority.
yes, sir.
Madam, what you
Lordship, I'm calling my senior lordship. He's coming, lordship.
no, we can dispose of
Yes.
based on the submission made by Mr. Trump. Okay, after a while, you answer.
But I He'll be there, but I have other.
We'll record it. He will be appearing for whom? State authority.
Only SP is there, superintendent of police, because the case was raised, sir.
Hello. Yeah. I have any taxes,
You have all the intelligence.
my lord.
Can we say no to you?
My lord. What? Thank you. Today, Advocate General will begin. Only for one indulgence. If I can start on Monday or Tuesday, subject to your question. I have little problem. I will be there up to 1 o'clock. I am for our response number 5.
The builder.
My lord, the builder, the main person. The relief is sought for against me. If your lordship it is
Which date are you seeking?
Monday or subject to convenience of
Monday is
Advocate General.
holiday. Monday is the holiday.
Monday or
Tuesday.
Tuesday difficult. 30th. More particular. On 30th. On 30th, my lord.
No. What is the
More particular.
what is the term? Okay, 28th we can try your part.
My part, I'll start.
Yes.
Lordship, I'm sorry for this.
No.
I'll be here now. Thank May it please your lordship. In this case, the other side opening remark was that there is a long history of the case. But those historical facts were not placed before the Honorable Court. What exactly was the history? So those facts are very important.
Now don't go to Sukafa.
And I will not go to Sukafa, I will go to 2008, 9 and 10. Because he has stated everything in the petition, but there was no submission.
Modern history.
Modern history.
Modern history.
We will not go to the ancient history. We will go to the modern history.
Modern history
or
of
maybe to the current
Torun Nagar.
affairs also.
Modern history of Torun Nagar.
So what exactly is his case, lordship? For that, lordship, I will have to place certain paragraphs from his affidavit, read petition, as well as his reply. Before taking your lordship to my affidavit is less to be required. Because whatever questions he has raised,
My lord, sorry to interrupt. The matter in which he took time, well, interim order, your lordship last interim order was 3 my Item 10. Sorry.
no, even without extension, we are not going to do anything.
No, we can, but we
That
cannot
can
find
be extended,
any-
lordship. I have no objection.
My clients are already there, sir.
That was in our mind, but
That game village matter, lord.
Game village. Advocate comment.
it's not a pass.
Sorry, my.
Interim order.
Mr. Chaudhary, we'll have to accommodate Mr. Pathak on Tuesday. We'll
Then,
try
my
to
lord,
con-
I'll give a reply finally after Mr. Pathak.
And I may have to give rejoinder because the facts which I will be raising now from his petition, he has not heard. So he will have to give a reply to that also.
My lord, one aspect which I missed out the other day before I would like to refer to one letter. If my lord kindly permits. One letter, my lord. It says that way I'll be continuing my thing. I'll just refer to 2 pages from the affidavit in reply.
My lord will kindly come to page number 602 of the reply.
6.
Because my learned friend the other day was referring to one bridge. It is the bridge was constructed by me, not by the government of Assam.
60.
602.
Yes. 9-1.
Yes, my lord. 9115.
Yes.
Views on petition of Meghamallar Estate and Services Private Limited in connection with construction of a bridge over River Bhorolu at Cheney 725 meter. In inviting a reference to the above, I would like to state the following in connection with construction of a bridge by Meghamallar Estate Services Limited for your kind consideration. NOC for construction of the bridge was issued by GMDA by order dated so-and-so on the basis of NOC issued by Water Resource Department by so-and-so. Subsequently, on the basis of the bridge and Torunnagar bylaw number 2 as the main access to the road to the project site, NOCs were issued in favor of Meghamallar Estates dated so-and-so and so-and-so. However, NOC could not be renewed or extended as the bridge could not be constructed by the party concerned, and stop construction notice had to be issued for not having a valid NOC as on the date so-and-so. This authority is also not in a position to issue NOC for the remaining 3 blocks in the absence of the aforesaid bridge. After construction of the bridge across Bhorolu River at Cheney 725 meter linking to Torunnagar bylaw number 2 and Anil Nagar bylaw number 1 will certainly enhance the connectivity between the 2 sites, and in a disaster situation like disaster management team may operate through the road bridge link to serve in the inside localities of Nobin Nagar and Anil Nagar directly to the project site as proposed by the petitioner. Now I'm skipping 5. 6 is very important, my lord. The developer Meghamallar Estates and Services Limited shall have to agree to spare a private thoroughfare of 24 meter wide across the project site
24
from
feet.
south.
24 feet.
Yes, 24 feet wide across the project site from south to north, directly linking Torunnagar bylaw number 2 in a disaster situation for use by general public and disaster management team. My lord, the purport of this letter by Chief Executive Officer to the Deputy Commissioner Kamrup was, the project has been conceived keeping in view, my lord, Torunnagar bylaw number 2, Anil Nagar bylaw number 1, bridge, and the bridge which the petitioner will construct. In addition to that, my lord, through the site, a 24 feet wide road will have to be constructed, and that in turn will be connected to Henduriwali so that it connects the Zoo Road. My lord, in the subsequent permission, this 24 meter is gone. So when a 9 feet project was conceived with this idea, 9-story building was conceived with this, how come 21-story permission, this condition is not there, my lord? Am I clear, my lord? Yes. So for this, I am drawing the lordship. Then my lord will kindly come to page number 623. My lord, this is the order by which the order for constructing the bridge was given at page 24, last para, 624. In view of above, I, Dr. M. Angamatu, Deputy Commissioner and Chairman, DMDA Kamrup, have no objection. His permission is given by GMDA GMC or any other authorized authority for construction of bridge over Bhorolu at Cheney 725 under the strict supervision of Water Resource Department along with the gradient. Regarding construction of the bridge, GMDA may review the earlier NOC issue. The entire work is to be completed by 15th of March 2023. So, my lord, this takes care of my learned friend's argument regarding construction of the bridge by the petitioner number 1. And earlier, my lord, when the NOC was issued to the petitioner, one of the further condition was there will have to be a 24 feet wide road connecting Henduriali to Churur. Now, my lord, now the permission which has been given to respondent number 5, this is not there. Now, earlier it was, 9-story and odd. Now this has been come to 21-story, yet this condition is not there. If earlier permission was the precursor to the present permission, then, my lord, how can we conceive of a permission without that condition? And in reply, I'll say some few other things, my lord, regarding, my lord, what they have done now. How, my lord, now electric submeter station has been installed. Even, my lord, that 24-meter road has been blocked. And I'll come to that. Let my learned friend reply. So I thought, my lord, I must point out this.
I appear for one of the party in this case. So all my learned friend, let them argue. Last of all,
You're for whom?
for the minister. Respondent 6.
Most influential part, according to the
I'll-
report. So I'm obliged. What my learned friend has just said, Lordship will kindly take a note of it because these are not pleaded and I want those to be recorded.
Read from my exception.
Anyway. So, Lordship, the story began in 2009. And the whole crux of the whole issue is related and encircling around the bridge. This bridge is the main area where this honorable court will have to take into consideration while deciding the subject matter of this case and all the pleas taken by the other side. If we look at the NOC,
Yes.
I'll come to the pleadings also, but one thing I would like to make at the very beginning, my learned friend till now has not disclosed what exactly is the width of the road. In 4 places, I'll come to that later on. The Lordship will kindly spare me some time. In 4 places in the pleadings, at one point they have said the road width is 7.5 meters. At one point they have said 8.0 meters. At one they have said 8.5 meters. And at one point they have said 6.57 meters. Till now they are not sure what is the exact road width. In the same pleadings and the reply, the petition and in the reply, they have taken in various paragraphs the stand that the road width is 7.5 at one place, 8.0 at another, 8.5 at another, and 6.57 in the last reply. They are still confused what exactly is the road width. But if we look, the first permission at that point of time, this private respondent number 5, this protect group was not in the scenario. Neither R6 was the vice chairman, or the minister. He started the whole project. Page 114.
114.
114. The first NOC at that point of time, GMDA was to give the NOC. Later on in 2020, GMDA is to give planning permit and GMC has to give the building permission, NOC. So the law as it was prevailing at the point of time, that was in the month of November 2009, the first NOC was issued.
What is the date? 10th of November.
10th November.
Yes.
With reference to your application for permission to erect, re-erect, etc. at Japurigog Beltola, dag number so and so, patta number so and so, of proposed 8.5 meters wide road. So Lordship will kindly mark this word. The definition also allows taking consideration of the proposed road also. I'll place that definition right now. Definition under the 2006 law. for residential apartment purpose in accordance with the plan submitted with it, with area of each floor and setback as shown below. So at that point of time, he took permission floor area up to 9th floor.
Correct.
Lordship have got it. Then setbacks are, and your application is hereby. Conditions are very important. Sanction for the aforesaid construction under bylaws 14 of the Guwahati Metropolitan Development Authority. Then number 2 has been struck off. 3, construction of the bridge to be started as per condition given in the NOC in GMDA white letter dated 22/10/2009 after due approval of WR department is received for dismantling the existing wall. So there's a guard wall, it has to be dismantled and the bridge has to be constructed. So when this first permission was granted to him or the NOC granted to him, the authorities considered that the proposed road width is 8.5 meters, which ultimately after construction of the bridge, it has been reduced to 8.34 now. So all these issues, whether he should get 2.75 or 2, is basically dependent upon the fact whether the road width is 8, 8.01 or below 8. If it is 8, he should get 200 FAR. Till 5th of May 2020. The law was amended on 5th of May 2020 when there is a new scope for enhancing the FAR up to 275 when it is between 8.01 to 15 meters road width. And beyond 15 meters also there is a scope.
What's the amendment?
Amendment I will place, Lord.
5th of
5th of May 2020.
What is that?
This new scope beyond 8 till 2014 bylaws, Lordship. From the beginning, the maximum FAR a builder can get is up to 2 or 200. The change took place on 5th of May 2020. And this was done in terms of the central government's various guidelines. It is not that state government has all of a sudden started this amendment procedure. It's a pan-India exercise which has been undertaken so that the roads are broadened and there are more people staying near the main road to reduce the dependency on public transport system and reduce the number of vehicles on the road. So clause number 3 says construction of the bridge to be started as per condition given in NOC of GMDA dated 22/10/2009. Then other conditions also Lordship may take note of, but which are not very relevant. Here, 2 important aspects is that while first NOC received by the writ petitioner, the proposed road was 8.5. Why it is proposed? Because the bridge was not constructed. Once the bridge is constructed, then it will become 8.5. This is his own submission. We are not putting any words, any facts into his submission. So the bridge was constructed in 2016 after a lot of litigation. Those I will place. Then he took an amendment of the NOC at page 115. That is of 29 July 2010.
Page?
Next page, Lord. 215.
115.
115.
Yes.
Here also, he took some amendment of the drawing. The building drawings he has amended and he took a fresh NOC. Subject, issue of no objection under section 25 of the GMD Act of 1985. Here also, with so-and-so of the so-and-so, building at Mauja so-and-so, on proposed 8.5 meters wide road for residential apartments. Here, there are certain changes in the structural drawing. He took an amendment, but here also 8.5 is the proposed road width mentioned in the NOC. And here also in clause number 3, your application is hereby sanctioned for construction of the following modification shown in red in the drawing. So those red were the changes. Then 3 says, with condition that earlier recommendation NOC given by fire to be followed so and so. And please condition given in the earlier NOC to be followed, clause number 3. Here also the bridge is yet to be constructed. So that is the condition given under the NOC issued in 2010. And these are his own creation. Respondent number 5 never entered until 2019. So 9 years ago, he said that the road width is, proposed road width is 8.5. Now coming to, I will go to 2017's NOC and 2018's NOC little later, Lordship. Why he has filed the litigation? What is his legal right violated here? That he has very clearly stated. There is no ambiguity what legal right he has been prejudiced, Lordship. So for that, Lordship, I would like to place certain paragraphs, but he has not come up with a full report which he annexed 3 pages earlier. But in the reply, he has given the full report after we annex the same report in our affidavit in opposition. Paragraph 4
How?
of the writ petition, because certain writ petitions I have to read out, Lordship.
Basic.
Page 6. That in the year 2011, when the petitioner had already procured all relevant permissions required for construction work, and when the construction work were in process, members of an errant organization called Torun Nagar Unnayan Committee started publicly opposing the construction of the RCG bridge on the false ground that the same would cause difficulties for residents of Torun Nagar. Based on public petition, respondent number 4 authority issued a notice dated 17/9/2012 to stop construction. In the said notice, the respondent number 4 authority had come to a finding that no 8.5 meters road was in existence. The organization also managed to convince the then Deputy Commissioner Kamrup that the project was one of a factor for flash flood in the area, and the construction of the bridge would further worsen the situation. Pursuant to these complaints and the observations of respondent number 4 that no 8.5 meter road was in existence, then the Deputy Commissioner, as the chairman of the District Disaster Management Authority, passed an order on 21/11/2013 directing the petitioner to stop the construction of the bridge and the work of the project. So at that point, 2012, absolutely correct, there was no 8.5 meters road. That is stated in the NOC itself. Proposed road after the construction of the bridge will be 8.5. So when the authority said in the hearing that today in 2013 or 2012, there is no existence of 8.5 meters road. Absolutely correct. He got the NOC in 2009 and 2010 on the condition of the NOC that clause number 3, that a bridge will be constructed as per the NOC given by GMDA. So when GMDA authorities before the Deputy Commissioner pleaded that we have today there is no existence of 8.5 meters road, but what he had pleaded before the authority, that also I would like to place from his own pleadings. In the reply, that is a part of our affidavit also. Page 609. I'm taking his document, not my document. Page 609. Last paragraph, Lordship. Access IV, that means it is 24, Roman 24. This is the order passed by the Deputy Commissioner that I will come and elaborate a little later. But what he has stated before the authority.
609.
609. I am little bit jumping the facts, but in my written arguments, I'll place everything in chronological order, Lord.
609, which clause are you referring to?
Last one, access IV, that means 24. a letter addressed to ADC.
What are these?
This is a part of the order passed by the Deputy Commissioner in 2013. It starts at page 604. There are two rounds of hearing, one by Agnihotri and the later one by Angamathur, two Deputy Commissioners. I'll place everything. These were not placed.
Part of
How the scenario changed, what are the difficulties he's faced, how it was overcome, what was the role of the traffic police, what are the role of the PWD, what is the role of the water resource department. Nobody has come to this conclusion that the width of the road is 8.3 for out of air. There were factual basis, Lordship. 609, and even yesterday, my whole team went there, Lordship, and redone the exercise. And it was found to be 8.34 yesterday also. So any commission, we are agreeing. I'll place a map of yesterday's findings. Lordship will kindly see. Have Lordship got it?
Yes.
A letter addressed to ADC on 7/1/2014 by MS Megmala, the repetitioner, Lordship, and services elaborating that the proposed project is having not very clear.
having tri-connectivity.
Tri-connectivity to the main arterial road, namely from GS Road to Torun Nagar by lane number 2, average width is 8.5. RG Borua Road from Ju Road to Kenduri Ali, Nobin Nagar 5.5 to 6, and Rajgarh Road to by lane number 6.6. The bylaw number 24 says, if there are multiple roads connecting the project, Lordship, then the road having the maximum width will have to be considered, not the other two. That also I'll place. So his own letter says 8.5, and that was in 2014, before the construction of the bridge. There one ground is that we are committing perjury. We are committing perjury because we gave a wrong statement before the earlier round of litigation before His Honor. What is he doing? If it is 7.5 today, then why he has stated 8.5 and 6.5737, then 7.5. In 4 stages, he has stated 4 different figures. And here it is recorded, and he has admitted this. He has admitted in his reply. This. He admitted this later in his reply affidavit when we pointed out this particular point. Paragraph 5 of his reply, Lordship will find that at page 164. Sorry, not paragraph 5. Paragraph 5 of his reply, that Lordship will find at page very long paragraph.
Page.
I'm just coming, Lordship. Just 1 second. Yes, page 580. He has admitted this later. That with regard to the statements made in paragraph 7, the writ petitioner company do not admit anything which has been stated in paragraph 5, which are contrary to record.
Page 580.
580.
Paragraph
5 of top plot. The petitioner have got
Yes.
The petitioner company submits that it is admitted that it has stated in its letter dated 7/1/2014 that the average road has been 8.5. So he has admitted it. However, the statement has been made therein based on NOC dated 10/11/2009 and 27/7/2010, Annexure 10 series of the decision, wherein it has been mentioned as 8.5, and the word proposed was inadvertently missed out in its letter dated 7/1/2014. Nonetheless, it is submitted that the petitioner company is unable to fathom as to how this factum leads to the conclusion that the writ petitioner has no legs to stand or not approaching the High Court with clean hand. So we are definitely taking the plea that he has not come with a clean hand. He himself said, and he is admitting now this later, that I have stated that it was 8.5. And 8.5 was proposed, absolutely correct, Lordship, considering that there will be a breach. So now coming to, so in paragraph 4 of the writ petition, his stand is 8.5. In this paragraph 5 of the reply, it is 8.5. So in two paragraphs, I am pointing out, his stand is 8.5. Paragraph 5 of the writ petition, page 7. The petitioner approached this honorable court in writ petition number 7057/2013 against the above order in what came to be ensured as protected legal proceeding. At this juncture, it is very pertinent to point out that in this proceeding, the respondent number 1 has submitted a report dated 28/12/2013 that Guwahati Metropolitan Development Authority to the Honorable High Court justifying why the project received legitimate approvals for construction. So we justify that why we gave the two NOCs in 2009 and 2010. We have considered that a proposed bridge is being constructed there, and therefore the road width will become 8.5. And the Honorable High Court all along in 2013 litigation, 2018 litigation, I'll place those judgment orders they have recorded, they have brought into record in their reply. I'll place those. Found no fault with GMDA. So all these were upheld. And we justified that in 2000. Their one contention is that we gave an affidavit before the authority deputy commissioner in 2013 that the road width is not 8.5. Yes, Lordship, it is not. It was not 8.5 at that point of time because the bridge was not there. The bridge was completed in 2016-17. Now coming to next page. As per the aforementioned report, the extract of which has been made available to the petitioner pursuant to an application under Right to Information Act, the average existing width road of Tarun Nagar Byline 2 up to the project height was computed as 7.5. Absolutely correct. In that report was of 2013. Existing condition, not proposed condition, that report contained. This computation was based on the building bylaws for the Guwahati Metropolitan Development Authority 2006. As per clause 58.9 of 2006 bylaws, floor area of road width of 4.5 to 7.9 would be maximum 175, and width of 8 meters and above would automatically attract the maximum FAR of 200 or 2.0 for residential building. Till this, Lordship, till these 2006 bylaws and 2014 bylaws, the maximum FAR a project can get is 200, Lordship, not more than that. That amendment came once more, I am reiterating, on 5th May 2020, I placed, when there is a scope for having 275. The report stated that the average road width of Tarun Nagar Byline 2 was taken as 8 meters during the year 2008. Even if it is 9, or even it is 10, or even it is 15, nobody will get more than 200 at that point of time. So GMDA authority, they also said 8. But at that point also, it was 8.5. But the FAR allowed then was 175 against the permissible 2000 due to variation of road width. The further report stated that the existing road now available as on date, which is in December 2013, along with Tarun Nagar Byline, is less than what existed in 2008 due to development of the area. Now coming to paragraph 7 and 8, how does things change? The transformation in the history. Even though this honorable court eventually ruled in favor of the petitioner and the petitioner resumed construction work, this resumption was rather short-lived. The public outcry against the project coupled with legal battles that followed causing crucial delays in the project timeline incapacitated the petitioner company financially and become unviable, unfeasible to continue with the project construction. So his project was declared as NPA by NETP. Therefore, paragraph 8. Paragraph 8.
Yes.
It was in the backdrop of above circumstances and after months of negotiation with the private part, the other project promoter, that is Protect. Respondent number 5. The project was handed over to respondent number 5, having his so-and-so, and the petitioner had arranged a settlement structure with the financer. The MOU of understanding dated 9/11/2019 was drawn upon between the petitioner and the respondent, the purpose of which was to record the terms and conditions whereunder all development rights for the project would then transfer to the respondent number 5 from the petitioner. This was followed by a deed of agreement dated 6/6/2020, which incorporated all the terms mentioned in the aforesaid MOU dated 9/11/2019. Two agreements were executed, Lordship. One, that was 9/11/2019. That is one, the first MOU.
Yes.
And there is a deed of agreement on 6/6/2020. Now, where he had committed the mistake. The amendment came on 5/5/2020. He did not read that clause. And that created all the problem for which Lordship is to consume time. I have to make all this stuff. I'll take your Lordship to the MOU now. Page 40.
Four zero.
40. The memorandum of understanding herein called the MOU is made on 9th day of November 2019, before the amendment, Lordship. Macvalar, one part, the other part is Protect. Then, Lordship, I am not. One important paragraph 42, page 42, second paragraph. It is pertinent to mention here that the total land taken for development from various landowners was clubbed together and made into a compact plot of land measuring 13 bighas. So when, Lordship, this amendment was brought in 2020, there are two factors. One is the road width, the other is the total measurement of the land. These two factors decide what will be the FAR. Earlier, it was not like that. Earlier, only the road width. So these two changes took place in 2020. So the land was of 13 bighas. Then next paragraph, and whereas pursuant to such right and authority derived under the development agreement and the consequent power of attorney, the first party had applied and obtained requisite permissions from different competent authorities and had commenced construction of residential project in the name and style Macmolar City Center Residency situated at byline number 2, Torun Nagar, Guwahati. This is very important, Lordship will kindly take note of that the project is located on lane number 2, Torun Nagar, not Anil Nagar Road. This is his agreement.
Where
Yeah.
are you reading?
In the middle paragraph, Lordship,
Yes,
page
yes.
42.
Yes.
The project is at byline number 2, Torun Nagar, Guwahati. This will have relevance in my subsequent submission, Lordship. Then coming to page 43, third paragraph. And whereas the construction was going on in the project, but by lapse of time due to some serious financial problems and local problems, further construction activities of the project was stalled. Looking at such stalling of the construction work and purchaser customers to whom the first party had agreed to sell flats units which were keeping an eye on the progress of the construction work, started pressurizing the first party to know as to when the construction will restart and the agreed flats will be handed over to them. The detailed chart is here. Next paragraph. In such an unexpected proposition and circumstances, further booking of flats were stopped as some rumors had already spread in the market, which resulted in irregular payment and of several installments against the project loan account of net fee, and the said account was slowly turning into a NPA, non-performing account. And the financial institution started pressurizing the first party to regularize the account, or cohesive measures may be taken by net fee to secure the loans advance. Then the subsequent paragraph, they have also registered under the FERA, RERA, etc. Now coming to page 45. And whereas as indicated above and the problems in which the first party have now landed into, the first party was not able to come out or cope up with the management of the project, as well as not able to manage finances, so to continue with the construction project and repay the installments and regularize the loan amount with net fee. Since in order to regularize the loan amount, net fee was asking a substantial sum against already defaulted installment, which in the given circumstances, the first party was not able to manage. And whereas finding no alternative, the first party approached the second party directly and held discussion and negotiation on a possible solution to the problem in which the first party was standing. Absolutely, Rotif. This is a distress agreement. So he was in problem. To tide over his problem, Rotif, he allowed the second party to come into the picture. Whereas after several rounds of discussion and negotiation, it was decided that the first party shall transfer and assign all the development rights, etc., etc. And also, last paragraph, and endeavor to work out a formula so that the already defaulted loan amount of net fee can be repaid. Next page. And whereas the first party does offer the second party to take over the entire project called Meghmolar City Center Residency, on being partly commenced, Lordship will also mark this, partly commenced on the said schedule below, and to undertake further construction, development and sale of units and making further investment to complete the project, which the second party accepted to do, subject to certain terms and conditions. Certain terms and conditions, Lordship 1, 2, Lordship may kindly come to page 47.3, that initially 11 crores will be paid, then 35% area. All these we are not very interested. What we are interested is, Lordship, page 49, the 35% area allocated to first party will also include the landowner's allocation as well as the
49.
page 49, clause 6. So there's an understanding that one party will get 65% share, the other party will get 35. But this is not very relevant. But what is relevant is I'm just indicating how they went ahead. The 35% area allocated to first party will also include the landowner's allocation as well as the flat books by the first party before execution of this MOU. To bring more clarity to the shares falling in onto first and second party, a detailed chart will be prepared so no dispute arises in future. Then 7 also, it's more or less the same line. Paragraph, clause 9, page 50. That the first party by proper deed documents agreed to assign the right to the second party to either use the already sanctioned NOC obtained from the GMC by the first party, and or if required to get the same modified, corrected, and also to apply and obtain fresh NOC permissions in their own name from GMDA, GMC, RERA, pollution control, fire department, APTCL, etc. And for that purpose, also authorizes to change, modify, rectify the drawings, layouts, plans, name of the said project, and also change, appoint, remove any consultant wherever necessary, and first party will not be entitled to raise any objections to that. So they agreed that I can change the project also, including the name. Forget about the structural changes or the design. And I can take a fresh permission also. All this they have agreed, and that is why they are in trouble now. Now coming to page 52. For this paragraph, this petition has been filed. Paragraph, clause 15. This is the main bone of content. Clause number 15.
Page
52. that the first party permits the second party to take possession and start the work from the day of signing of this memorandum of understanding, and the second party will take care about the NOC, permission, renewal, etc. Further, first party has no objection if the second party uses or at its own cost apply and obtain fresh permission and or renew by modifying the existing NOC as per bylaws, and in such an event, the benefits therefrom will be available only to second party. This is the first bone of contention. Any benefit, the second party will be entitled. That both the parties agrees that above 35% of total saleable area is as per FAR allowed in above referred present NOC received from the competent authority shall only be given to the first party by the second party, and no further area share will be given by the second party to first party, even the second party gets additional FAR under provisions of law. Till that moment, 5th May 2020 was not there. This is of the previous year, Lordship. The date is of November, 9th November 2019. So before the COVID. But after the, once the COVID started, the scenario changed in a lighter when I'm saying. So when it was given, 35%, 65%, all these shares as per the existing NOC, existing law. And in case in future something changes, the benefit will accrue to the private party, that is R5. And the petitioner will have no right. As because
the last line of paragraph 15, can you read once more?
Yes,
That both the parties agree that the above 35% of the
of saleable area is per FAR allowed in the above referred present NOC.
Yes.
Till that moment, NOC was of 2018. Under the new law, fresh NOC was issued in 2020 in the month of September 10th and 19th. I'm coming to that. Chronologically, I'm going.
Is there any reference to the NOC?
Yes, I'll because what he have done, Lordship, in 2016, he applied fresh NOC because earlier NOC was exhausted and it was not given by GMC because there is pending litigation, and he went come to the court again for a direction that the GMDS should immediately issue him the fresh NOC. So he got a fresh NOC in 2017, another NOC in 2018. Those I am placing, Lord, in few minutes time.
Maybe in the narration there is a reference to the NOC.
Yes, Lordship, that is there. I'm just straight where I can come.
Yes.
Page number, Lordship, 100 and
No, in the narration of this MOU, is there?
narration. They have annexed it at page 116.
If that's NOC.
Fresh NOC. 42. Annexer 11 series, 116 and 117. I'm placing, Lordship. So here,
Yes, in the narration of that page 42 is there.
yes,
Second last paragraph.
exactly, Lord. So this NOC he got on 17th May 2017, page 116. Here the road width is mentioned as 8 meters wide.
No, these, sorry, these 42, these are of 9 and 10. You are talking about the
11, series 11, that is series 10. Page 116, Lord.
116.
116.
Here, yes, it's there in page 44. It has to be there in the it's there.
Yes,
Page-
Lord.
page
But in
44.
the repetition, I am
No, repetition there, the whole document is there, but in the MOU, there has to be a reference.
Reference.
There is a reference.
Lordship.
Page 44, the first para on the top. In fact, second para.
I'm sorry, Lordship. I'll just come back.
First party has to once again renew the permission right. 17,517. Is this you are referring to?
Yes, page 44. Yes. Page 44.
44. The
Yes.
17,500
17/5 2017 is mentioned there.
and revise the permission taken within the next paragraph.
2018. And RERA,
311 2018.
yes.
Revise the permission.
Yes, 311 2018, page 117. that document.
44 also is there.
Yes, Lord.
There after the second
There's a
paragraph.
reference.
Yes.
The documents are annexed in
Yeah.
page 116 and 17.
Okay.
So here, the interesting point and what is the deviation from the earlier to NOCs.
Seventeen five is in which page?
Page 116,
116 and
116,
311 18.
117.
Oh.
So here, page 116 says, with reference to your application for permission to construct, etc., with road width of 8.0 meters wide. Here it is not proposed 8.5 now for residential, etc., and his
No, it's proposed. Oh, 116.
116, it is not proposed,
Oh.
Lordship.
Not 5 is okay.
115 is 2010.
Where?
115,
116 where he proposed it.
yes, proposed.
Example.
Proposed 8.5, 115. That is of 2010.
And in 116 where
In the third line of the top paragraph, fourth line, 8.m,
on and yes.
8.
On 4.9 m and 8.0 m. Why?
Yes, Lordship.
What is 4.9?
For the other road is not relevant. I'll come to that. The law says the road which has the maximum width, that has to be considered for permission. So 8.0 m width for residents. So he got, his earlier FAR was 175. This time he got 200 FAR. On the basis that the road width is 8. He was not interested whether it is 8.01 or not, because at that point of time in 2017 and 18, there is no scope of getting more than 200 FAR. Even the road is of 12 meters wide. Also.
That was 200 was the maximum.
Exactly, Lord. So the authorities also, because earlier it was 8.5.
Right.
9 and 10.
Proposed,
Now it has 8.
Proposed.
Now
Now
here Lordship will see the conditions below. Your applications, etc. Here there is no mention of the bridge. Now, because the bridge has been constructed by this time.
Right.
So when the first two NOCs were granted in 2009 and 2010, there it was a conditional that a bridge will be constructed. If the bridge is constructed, the road will become 8.5. Once the bridge is constructed and there is no scope of getting any additional FAR, whether it is 8.1 or 8 or 9, so he applied for, under the existing law, 8, and he got 200 FAR. Next page also, it is, the condition does not indicate about bridge, so bridge was already constructed, so he got 200. Now coming back to the agreement once more. Page 52. So that paragraph 15 is what exactly I wanted to show. And it is more or less replicated in the subsequent memorandum of agreement. Deed of agreement, DOA. It is MOU. MOU is of November 2019. And then the deed of agreement of
54.
Page 52. 52, paragraph 15.
It's a part of DOA.
It's a part of the MOU.
This were having a look at 52.
Page 52.
Paragraph 15.
Paragraph 15. I read it once more. I am reading it.
Yes.
That the first party permits the second party to take possession and start the work from the day of signing of this MOU, and the second party will take care about the NOC permissions, renewals, etc. Further, the first party has no objection if the second party uses or at its own cost apply for and obtain fresh permission and or renew by modifying the existing NOC as per bylaw, and in such an event, the benefits therefrom will be available only to second party. That both the parties agrees that the above 35% of total saleable area is as per FIR allowed in above referred present NOC received from the competent authority shall only be given to the first party. That means the petitioner will get as per the existing NOC's FIR share by the second party, and no further area share will be given by the second party to first party even if the second party gets additional FAR under provisions of law. It is very clear, and that is creating problem for him because now under the new law, he got 275 and he wants more share now. That is the main cause and for which arbitration process has already been started, because we took a plea that the issue which is raised here should be actually argued and actually taken to a arbitration proceeding. Page 54, there is a provision for arbitration also. But his cause is now that GMDA has wrongly given him 275. And that is why we are trying to defend the decision of the GMDA while granting him the planning permit and subsequently the building permission given by GMDA. Those I am coming a little bit later, Lordship. Now coming back to the writ petition, because we have to look at his pleaded case.
No, but Mr. Yeah,
Lordship.
here in clause 15, there was already a stipulation that in case the second party is in a position to expect further permission for more area,
Yes,
then there will be no additional gain to the first party.
exactly.
Now, if that was the stipulation, now will the challenge, how can the challenge be maintained?
Continue. I am not.
How can the challenge be made if they are already in contemplation that I enter into an agreement?
Yes, now what they are saying, their cause of action is that we have done a mistake. GMC, the government authorities.
No, what we have heard from you, we have not just.
Yes, no, facts are not complete.
In the
Lot of
midst
other
of
facts
the
are there.
hearing, you say that there was change in the bylaws
Yes,
and the FAR could be enhanced.
enhance.
Earlier, there was a seal,
Yes,
200.
yes,
Now, because of the change of bylaws, you have enhanced this FAR to 275 or what.
Lordship.
And there is a stipulation in 15 that in case the second party is in a position to get further FAR by process of law, there will be no further gain to him.
Lord.
If that was the stipulation, then what is the challenge based on?
Here in the writ petition, the writ petition is challenging to that planning permit of 10th September 2020 after this agreement, and the building permission granted by Guwahati Municipal.
No, what we are under question status, but what is it based on?
Based on Lordship, that is what Lordship, that is what is troubling, because his whole case is, I am coming a little bit later to his writ petition, that prejudice has been caused to him, financial prejudice. And had he got 275 at that point of time or 200, he would have got a better bargaining power while negotiating with the respondent number 5. These are his pleadings, whatever I am saying. That's why I am taking your Lordship to this, the writ petition as well as the reply. The cause of action is very clear. The cause of action, Lordship, will find paragraph 11
of
the writ petition, page 12. I'll come back again to paragraph 9, but straightway, whatever is troubling Lordship, that is the actual difficulty or the bone of contention. Once more, I am using the same term, paragraph 11, page 112.
Yes, please.
That at the outset, it is submitted that it is the grievance of the petitioner that the respondent authorities have contradicted his own statement made before the Honorable Court, and in doing so, they have given benefit of extra FAR to respondent number 3 in stark contravention of the underlying legal framework to the utmost prejudice to the petitioner in several respects. So prejudice in what form? Now, if you look at the complete pleadings, it will come to the conclusion that in 2013, the JMDA authority before the deputy commissioner's hearing process said that the road width is not 8.5. Actually, today also I'm saying in 2013 it was not 8.5. That will become 8.5, that road width, once the bridge is constructed. And he took the benefit. While he started the construction in 2010 or 9 after the NOC, if he had completed the project in 2012 by constructing the bridge without there any objection from the local Unnayan Samitis, Lordship, nothing would have been there. Because at that point of time, road width 8.5 was considered by DMC or DMDA and gave him the planning permission as well as the building permission, construction permission, NOC. Only because it got stalled, because there was objection regarding the bridge construction, his whole project got delayed. And he failed to repay the loan amount. But those facts are also very important. The deputy commissioner in 2013 that the bridge cannot be constructed there. Again, it was reopened in 2016. The final conclusion that the road has to be constructed. The same deputy commissioner, the persons are different, but the authorities is same. So he was prejudiced in various aspects. What are the prejudice caused to him? He is not uttering a single word in the whole writ petition that a 10-story building or 14-story building has been converted to 21. Because when it was given, when this project was handed over to the respondent number 5, what was the status of construction? That also is there. Yes, that Lordship will come. Page number 75. So when it was block number 1, Marigold, foundation complete, first slab casting completed, column, etc. Second slab shuttering completed. Second block, foundation completed, casting up to the 4th slab completed. Third is foundation completed and column of ground floor post completed. 4th block not yet started. Now we have the 5th block. So these 2 blocks will have 21 floors. Number 1. Number 2, Lordship, in one of these floors, he also has got enhanced FAR when he got the phase NOC in 2016 and 2017 and 2018, when his FAR was increased from 175 to 200. So he also wanted to enhance the building floors. While the private party, we did the recce yesterday, Lordship, we found that there were 900 columns in one of the buildings. These two were yet to be started regarding the 21st floor. There were 900 pilings. This party has added another 600 pilings. And that submission they will make. But in all this permission, I will take your Lordship to the subsequent permission which are put to challenge. Before any person can occupy the building, the authorities will inspect it and have to give a occupancy certificate under the provisions of law. If there is anything wrong in the construction regarding the structure and etc., nobody can occupy that building. Lordship can direct that. Otherwise, we are legally and statutorily bound to do that. Nobody can occupy that building. Whoever buys it, occupancy certificate must be there before a building is allowed to be occupied by any person. So I'll come to those. So at the time when the project was handed over to R5, two of the structures were yet to be started. The foundation work was also not started. And
4 and 5.
Here up to 4, but 5 is there also.
5 is new.
5 is new.
And 4, it was yet
Not yet to start. So therefore, they have rightly not pleaded anything in the petition because they know. But in their submission, in their oral submission, a very serious argument was made the other day. The other day one is that how the road become wider. And the other one is that how a 14-story building can become 21-story building. I read every word of both the pleadings, read petition as well as the reply. Not a single word is there. Their whole contention is that in their negotiating table, they were in a weaker position because he did not knew that GMDA at one point of time, on the basis of the law in force, will give them 275 FR. As a result, according to him, there is a windfall gain of 150 crores. These are pleaded things. I am not taking anything from my own. And for that, he is before this honorable court. So whether that is permissible, whether this is maintainable. So coming further, yes, Lordship will kindly come to paragraph 9, page 10. After the MOU was signed and maybe the deed of agreement also, by letter dated 10/11/2022. This letter they have not divulged before this honorable. What exactly is the content of that letter? By letter dated 10/11/2022, the petitioner informed the R2 that the project had been duly handed over to the respondent number 5 following all apparent, available, transparent and known project transfer formalities of ongoing project. The letter mentioned that the respondent number 5 subsequent to the handing over of redesigned the whole project and obtained all necessary new clearances and permissions, including the 2 permits from the respondent authorities, which incidentally forms the subject matter of this writ petition. Planning permit from the office of the respondent number 1, dated 10/9/2020, and no objection for construction for respondent number 2, bearing dated 19/9. These are the 2 which are put to challenge. If Lordship is pleased to look at the prayer portion, page 24. Certiorari should not be issued to set aside and quash the GMDA permit dated 10/9 Annexure 7 series and GMC permit dated 19/9. And page 25, certiorari setting aside and quashing the decision of the respondent authorities to grant FR 275 to respondent 5 instead of FR 175. He himself got 200 FR in 2019, 18 and 17. Now he wants that with the new law, somebody should get 175. So the other day, lot of stress or emphasis was given to page 97. Page 97, it draw a map, sketch map. So page 97 is related annexure 8. If Lordship is pleased to come to paragraph 10, page 11. What is clearly discernible from these 2 documents is that the road width of the subject road was mentioned as 8.35 meters instead of figure of 7.5 meters submitted by the respondent authorities in a sworn affidavit before the court in WPC 7057 of 2013. So again, going back to the same story, same plea, thereby entitling the respondent number 3 to a FR of 275 as per the amended bylaws 26 of the Guwahati Municipal Guwahati Building Construction Regulation Bylaws 2014, amended in 2020, which provides that an existing road width of 8 meters and below 15 meters would be entitled to FR of 275 or 2.75. A copy of the self-made map of the area based on record is annexed here, annexure 8. So now, lot of arguments was made on page number 97.
Yes.
So they themselves have said this is a self-made. So this is not to be considered at all. So I am again submitting, if Lordship wants, a commission can be constituted and go and verify. Yesterday, our team went again I'm giving an actual so that we can visualize what exactly is there. So that we can relate these facts with the law in place. So GS Road is there, Lordship, then Turun Nagar, then the entry point 8.05. Entry point. Then the bridge is 4.5. Bridge is 4.5. Bridge is 4.5. In our report, it is given. The report I will come little bit later. And the area in front of the project. In front of the project, Lordship will see the bridge straightway comes to the frontage of the project. The project is a huge area. So 12.4 meters. This. And while constructing the road, this additional 4 meters was given away by the writ petitioner himself. That was one of the conditions. My friend very proudly said that the writ petitioner has constructed the bridge. I fully agree, Lord. And one of the conditions that he will have to give some land so that the public will have no difficulty in accessing the bridge, number one, and there should be no difficulty in maneuvering the vehicles there. And that will become a public property. That Lordship will see in the writ petition. If necessary, relinquishment of land is required.
On the western side, there's a road comes to an end.
Yes, Lordship. That is Anil Nagar Road.
No. The bridge to come towards the area in question. If you go towards the west, that's what it was the east. There's a, is it a,
Yes,
dead end?
finally it is got a dead end.
There is no road there.
There is no road. And if we had taken, suppose, Anil Nagar Road, which is actually the end of Anil Nagar Road is facing a dead end. But that road we cannot consider. We have to consider the Turun Nagar Road by length too.
We'll come back.
Will.
What is to be done there? Just a second, just a minute. He's on person. We can. Mr. Deka, you are appealing.
Yes.
You file affidavit.
We filed our affidavit. But we are led by Mr. Kiran Chaudhary.
Can it be taken up for disposal?
But today,
Not today. In his presence.
yes.
Lordship, I have made a submission because in its affidavit, government has submitted an order. This order reflects that the decision has been taken on the basis of report dated 25/2023. Whereas in my writ petition, I have submitted that the proposal was submitted on 13/1/2021. As per the act,
What is your name?
Vikash Bucha.
Pucha, we are not going to the marriage today. If you want, you can have it for disposal.
Lordship,
If you broadly agree upon the fact that no further
no problem.
further pleadings is required.
No problem with that, my lord. But only my submission is that I have grievance against the actions of respondent number 4, that is Director Vigilance and Anti-Corruption. Till date, Director Vigilance and Anti-Corruption has not submitted anything. Lordship.
It's an adversarial litigation. He may not contest if the inference will be drawn against him. Where is so ordered? Is anybody appealing for 4?
before, Manoj, they were represented. In fact, they had brought it to the notice of the court that the sanction had been refused. That refusal of the sanction is not under challenge now.
There's an order of refusal of sanction.
Yes, Manoj.
My lord, they have mentioned that 13/1/21 and the report which has been dismissed. The report was 25/2023 during the pendency of the suit. They have not taken any permission from this court that re-examination. There is no provision of such re-examination in the court. We have already submitted that our complaint has not been considered yet.
We'll consider your submission.
Your right.
Four is otherwise served or not?
Notice has been served on the 20th March itself.
Four has been served.
Yes, my lord.
Oh yes, government council is appearing for 4.
Yes.
Any government council? State council? We have had that, we have recorded the J. Henrik had appeared for all the responses. No, we are not taking up today. We can take it up any other day when convenient to. Today in the midst of the hearing, we don't know how. But if you agree upon the fact that.
I think there is a last occasion, there is an order, my lord, where the other petitioner was not present.
Yes. Then it will continue for him only.
My lord, he is there. Council is there.
You're for the
petition.
for the first petition.
So what had happened in this case? Now, my lord, the government has refused to give the sanction. So therefore, my lord, this petition has become infructuous. They will have to file a fresh petition challenging that.
Where is that order?
Yes, my lord, it was brought on record. In fact, there is an order when on an earlier occasion, Lordship dealt with the matter. If your Lordship would kindly have our affidavit at page 94.
No, we'll have this matter on merits or some other.
Okay.
Whenever you convenient for both of. Since he is appearing in person, so we
No problem.
upgraded the matter.
My lord.
Let me appear. This is on.
Any day
When can
convenient.
you appear, Mr.
Any day in the next week, my lord.
Next, put the hearing date here for matters
Yes.
on Tuesday, the Thursday. Wednesday we can try at around 3 o'clock. Informally we speak at 3 o'clock.
My
Over there.
lord. With the understanding, it will be
Yes.
taken up in the
That's
second.
it.
If-
Thank you.
The petitioner number 1 is represented by
Richard.
Ravi Sharma council, whereas the petition is appearing in person. For some, Viken Chaudhary council is present for this one number 5.
Yes.
Who is for 1 to 4? Government council, any government council? Yes, Purva. Then state council is present for Chaudhary Senior council for the response for 5 has submitted that if you fact that the application for grant of sanction
Prosecution sanction denied.
for grant of prosecution sanction has been refused, and they say this is not challenge. This petition will not be maintained. So no, will not have any further cause of action survive. This aspect of the matter could be considered on the next step. Para as acted by the party is on
Wednesday.
give the date please. 29. But ideally after 2 o'clock.
My lord, my lord.
I'm coming to paragraph.
Mr. Henrik, this matter where petitioner was appearing in person, you had appeared for 1 to 4. 4 has not filed the affidavit.
I think my lord, he not will appear, but he is on the way.
Tell you record your name. Let record it as Barua. Let your name be there, but they take cognizance of the matter. Next witness we are taking up for final disposal. And we have been apprised that the application for prosecution sanction has been refused, and that order has not been put to challenge. So maybe also it has come from because yes.
May I again continue with the writ petition, Lord?
Yes.
Page 13, paragraph 12.
1-3.
Paragraph 12 of the writ petition, Lord, page 13. That in the year 2008, the road width was determined to be 8 meters by the respondent authorities, and therefore the entitlement of FAR at that time was 200, as the reported 2006 bylaws.
Page 13 paragraph?
Page 13, paragraph 12 of the writ petition.
Okay. Yes.
As no objection certificate issued by R3 in 2009 in favor of the petitioner indicates the proposed road width then was 8.5 meters. Even though the entitlement to FAR 200, the same stood restricted to 175. The same picture continued in 2010 when the proposed road width was determined to be 8.5 meters, but the FAR was restricted to 175, even though the petitioner's entitlement was 200. It is pertinent to state herein that FAR is allowed based on existing road width, and proposed road width is considered for determining the setback so that the provisions for road widening in future may be facilitated. So they also know that in future there is a scope for expansion of the road width. Then paragraph 13, above continued till 2016 when the permission under NOC was granted based on actual road width and not proposed road width. As the no objection granted in the year 2017 and 18 indicate the actual road width was determined to be 8 meters and the FAR allowed was 200. It is pertinent to mention herein that the FAR of 200 was granted because the approval of the petitioner was given on the basis of 2006 bylaws, whereas FAR allowed for road width of 8 meters and above was 200. The 2014 bylaws also reflected the same computation as 2006 bylaws. I have no objection to this, Lordship. There is no quarrel on that. Coming to next paragraph, Lordship. In the light of above, it is submitted that when these irregularities, non-conformity of GMDA permit and the GMC permit of 2014 bylaws came to the notice of the petitioner immediately approached the respondent number 5 for clarification. It is important to bear in mind that not only was there a difference in FAR granted to the petitioner when the petitioner was handling the construction work of the project and the respondent number 5 post the handover, but the petitioner's logo and other identifiers had been released by the respondent number 5 in a brochure pertaining to sale of flats in the project. In other words, as by associating the petitioner's name with a project that was built on illegal grounds, the respondent number 5 was putting petitioner's reputation at serious jeopardy. No comments to offer. These will be part of the arbitration proceedings. Now, 15. While later dated 10/10/2021, the petitioner informed R3 that it had obtained FAR 275 illegally and same went against the spirit of legitimate approval process. So I do not understand what is the spirit here. Everything is on factual and objective analysis. It is pointed out to the respondent number 3 that the applicable FAR to the for the project as per the existing bylaw was not 275 but 175, since the road width was determined to be 7.5 by the authorities themselves in 2013. Now, again, he has come back to 7.5 now. How he is changing regarding the measurement. The respondent number 5 was also informed that it attempts to claim benefit by shifting the boundary wall in the adjacent road, which did not form a part of the relevant provisions for FAR calculation, tantamounted to suppression of act to the authority to gain undue advantage. I do not understand what exactly he meant by this, because there is no giving up of land by the present builder. it is submitted that the respondents have acted in collusion to misrepresent the actual factual metrics surrounding the project to make sure that respondent number 5 gets the benefit of additional FAR. Pausing here for a moment, I want to know, Lordship, from them. It is submitted respondents have acted in collusion, but with whom? They are silent, absolutely silent. To misrepresent the actual factual metrics surrounding the project to make sure that the respondents 5 get the benefit of additional FAR. In other words, respondent number 5 had tried to make a claim of extra FAR by shifting the boundary wall of the Anil Nagar byland number 1, which happens to be narrower of the 2 roads abutting the project land in question and hence cannot be considered for building permission regulation as per footnote of 24A1 of bylaw 2014 and showing a wide road in front of the project which is completely impermissible. I'll place this clause, Lordship. This clause very clearly says, may I pause here for a moment? Let me place this clause. 2014.
24A1.
Yes. Two 2014 24 24 na? 20. I'll just place it. Yes. 24A planning regulations, minimum setback, etc. Now on setback. Petition page 1 page. Page 1 page. APM mark করা আছে। Yes, Lordship. Page 121. Starts page 120 last. Planning regulation, minimum setback of the building or the structure from the prescribed street line. I'm skipping the front setback, etc. Proviso. Provided that the authority shall prescribe different front and rear opening space, front and rear setback, considering space required for widening of road and minimum space required. In case of building abutting 2 or more streets, the wider streets shall be considered for determining building height and other regulations. Front setback of all categories of the building shall be as per 24A1. So there is no dispute on the setback. Regarding the consideration of the road, when there are more than one road, Lordship, then the wider road has to be taken into consideration. So I am reading paragraph 16 again, the page 16 part. Hence cannot be considered for building permission regulation as per footnote in clause 24A1 of building bylaws, showing a wide road in front of the project which is completely impermissible. Pausing here for a moment once more, Lordship. From day one itself, from 2009 itself, Lordship, only one road was considered, and that was the Torun Nagar byline 2. He himself had taken 4 permissions on the basis of the same road that comes from GS Road up by crossing the bridge up to the project. He never took permission on the basis of the Anil Nagar Road. Anil Nagar Road, Lordship will know that from Rajgarh after the bridge, here the road goes towards Anil Nagar. straight way along the river, there is a small narrow road. That is what he is meaning. Along the river, that road, which hardly people use it. The only road main thoroughfare is the road crossing the beach. And he himself took all the permissions on the basis of Torunnagar Pipeline from the Namkhara.
Anil Nagar was not the consideration.
It
Anil
was
Nagar.
never. It was never. And had there been no road, then Anil Nagar had to be taken into consideration if there was no bridge.
Bridge is also there.
Now bridge is there. So now road is there. And the bridge directly comes, the lordship takes the drawing one for one.
Yeah.
Lordship will see the middle portion, the road towards Anil Nagar Road. That is, the project is proposed plot of land 12.7 meters, and in front of 12.5 center point, the bridge is there. Bridge is 4.5. And then it goes straight up to Torunnagar, that Torunnagar Cultural Center on top. Then Torunnagar main road, then it leads to GS Road. So that is the road. Never at any point of time, whether the planning permission and building for NOC were applied by the writ petitioner or by the private respondent number 5, never they saw this road, and it cannot be considered because this road is narrower than the other road.
And you have shown the provisions of 24A1. If
Exactly,
two roads are
Lordship.
there,
Yes,
divider has to be taken into
weather has to be taken into consideration. Even assuming that this extension exists, it is a matter of record that this part of the road is dead-end road. The dead-end road is the Anil Nagar road. So that road is never considered on. As per clause 23 of the 2014 bylaws for dead-end road up to 250 meters in length, that is not relevant because that road is never taken into consideration. Now, coming to paragraph 17. While later dated 29/10/2022, the petitioner requested respondent number 5 to release all approved drawings for the project since upon a scrutiny of GMDA permit and GMC permit, the petitioner had good reasons to believe that the approved drawings did not conform to the 2014 bylaws. The respondent number 5 did not respond to this letter of the petitioner nor provided the drawings as sought for. He is absolutely correct. It did not conform to 2014 bylaws. It conforms to 2020 bylaws. To make out a case, he is hiding or he is suppressing certain very important factual and statutory provisions from this honorable court. I am not reading this later parts I will show later on. Paragraph 19. Paragraph 19.
Yes.
While later dated 19/12/2022, respondent number 3 informed the petitioner that the planning permit was issued as per the provisions of 2020 bylaws, which had amended the 2014 bylaws to provide the affair of 275 for the road width of above 8 or more. Be that as it may, the fact, however, remains that the respondent authorities, despite multiple queries from the petitioner, have not provided any justification for their contrary calculation of the road width, as evident from the statements made in the writ petition in 2013. Much water has flown by Borolu as well as Brahmaputra during 2013 and 2016. And the planning permit issued to the respondent number 5. In other words, the point for consideration is non-application of 2020 bylaws, but what calls for consideration is how the road width, which was all along 8 meters, all of a sudden become 8.35 meters. The record does not indicate any objective material to show that the road width is 8.35 meters. I will place it from the report. Coming to the next paragraph 20. That it is submitted that if the extra affair is illegal, then the same ought to be barred from construction by the respondent number 3. On the contrary, if the extra affair is indeed legal, due to the amendment of the bylaws in 2020, and the actual road width is now being changed to 8.35 as indicated in the permit issued to the respondent number 3 by respondent 1 and 2, then the only inference of this is twofold. This is important. Number one, the respondent number one had committed perjury by giving false statement to this honorable court in 2013. And number two, petitioner was unjustifiably denied the benefit of extra FAR, which it could have claimed during its negotiation with the respondent number three before the MOU was drawn between them. So this is the main grievance, that he did not have good bargaining power or more effective bargaining power. Had he got 275, he would have got 35% of 275 FAR. The petitioner could have easily accommodated the extra FAR in the 4th, 5th, 6th, and 7th building, which were not constructed at the time of resumption of the construction work in 2008. Now he is saying 4 buildings have not been started. I do not know what are the factual things here. And had remained unconstructed until handing over the project to the respondent number 5. So where is the problem that he was other day saying that the foundation was for 14 stories, how a 21 stories building can be constructed here, when the foundation work itself had not started. His own record I am placing. They are conflicting submission before this honorable court. And there is a deliberate attempt on their part to misguide and mislead this honorable court. In the process, apart from violation of its legal right. Now, what legal right we have violated against him, Lordship? The petitioner suffered serious prejudice and huge financial loss. That is the correct position. Yes, in distress, he committed that he will not take any additional FAR if they subsequently gets. He knew that they cannot, in fact, the bylaws very clearly indicate, I will place that provision, that any building permit or NOC is not transferable. There is a bar. So this new party will have to apply afresh. That I will place immediately. Bylaw 14. That is in 2006 bylaws. Section bylaw 17. That is 2014 8 Roman 4. 2014 8 Roman 4 bylaw. Planning permit, building permit not transferable.
Yes.
Bylaw 8 says procedure to be followed, etc. Roman 6. The planning permit and building permits are not transferable except to legal heirs. So if some windfall gain has been resulted because of change of law, for that Lordship, GMD or GMC is not responsible. And we have not violated anybody's right. If suppose they agreed to give some additional share, both parties will be happy. I do not know whether they will be happy or not, but he will be certainly happy. But in either situation, the government authorities have not committed any mistake. There is no arbitrary action on our part.
You tell me one thing, under the new existing bylaws,
Yes, Lord.
what is the, is there any violation with regard to the FAR allotted vis-a-vis the width of the road?
Absolutely not, Lord.
What is the present permissible limit?
Permission 275 under the present factual.
For a road width of how much?
8 plus. When it is more than 8, up to 8, it is 200. To 8.001 also. Fraction of
More than 8.
More than 8, then it is 275. Up to 15. Beyond 15, it is 300. For this category of construction project. I'll place that. So it is very clear on that. That from 8 to 15, that category was not there earlier.
Are you your submission directed towards the fact that the alleged violation of building permission has got nothing to do with the new permission, because under the law existing,
Exactly.
they are entitled to the and
Absolutely. Suppose
since permission is also not transferable, there is an independent application. They had applied and got the permission in
exactly
accordance with law.
that is my case. That is my suppose we have refused to give them 275, instead we gave 175 or 200. There would have been a writ petitioner there. And what would have been my submission at that point of time? Whatever we have done, how to measure the average width, we followed that.
What about the hot haste in giving the permission?
That within 10 days we have to do it. That is also under the law. That is also under the law. If we within 10 days of application, we have to complete the inspection. We have completed the inspection and send it to GMC. GMC in 10 days time gave it. If we do not do it within 45 days, then it is considered to be granted deemed permission. That is the law. They are making all these political statements. There is absolutely no haste. Whatever we have done, I will place that provision. Let me place that provision also. The time limit. Time limit is given. Pilot 13.
Is it enacted?
In the same. It is in the 2014 bylaw.
You have to hand over a copy.
10 days was there. 10 days. 10 days. Application. Yes. First, Lordship will kindly come to bylaw number 9. If it is 2014, have Lordship taken 2014? Bylaw number 9. Inspection after submission of application. Each inspection shall be made within 10 days following receipt of application. Very clear, Lord. So the application we received on 3rd, we completed the inspection, and on 10th, we have prepared the planning permission. We are not the authority to give the NOC now. We send it to GMC, and on 19th, GMC issued the permission, and on top of that, this was already a project which was going on from 2009. So this is just a renewal sort of. It is not a fresh project. So maximum thing we have already done. Only thing which we have to assess now was that what is the road width under the new law. Whether it is 8, below 8 or beyond 8. Earlier 8 or beyond 8, it is the same affair there and
200 maximum.
Doesn't make any difference, irrelevant. But now we have to go for a very minute assessment of the road width. That fraction will give either 200 or 275. That 150 crores calculation, according to them. It is not correct or correct, I do not know. It is their assessment, and repeatedly they are saying that huge windfall gain of 150 by violating norms. So each inspection shall be made within 10 days following receipt of the application. The authority shall determine that the plans submitted conform to the requirement of the Act, rules and these bylaws, and inform the applicant as per provisions clause 17. However, if inspection is delayed beyond 10 days, the applicant shall intimate the authority in writing, and the authority shall complete the inspection within 7 days of receipt of such intimation. And Lordship will now come to bylaw 13. Application for planning permit shall be disposed of within a period of 30 days. From the date of receipt of the application for building permit shall be disposed of within a period of 45 days from the date of receipt of planning. In the event of failure of the authorities to grant planning permit or the building permit within the stipulated period above, the permit shall be deemed to have been granted, and the applicant may proceed with the construction with written intimation to the authority concerned, and necessary permit fee to be deposited within 10 days. So we are bound by the statutory norms. In fact, I am very happy to submit before this honor. Now the law is such: if the building permission is considered is applied for ground plus 1 or 2 stories, Instantly online approval is done. Online. I submit everything as per order. Instantly, I will get the printout of the permit. No inspection is also required. Only thing is that a qualified architect and the town planner must give a certificate.
So he will face penalty.
Exactly, Lord. So this story of 3 days, 7 days, Janmashtami, Madhavdev Tithi has no bearing here. So whatever we have done, it is as per statute, and if we have not done, then we would have violated the statutory provision. Or the officers would have faced disciplinary proceedings. By waiting for 7 days or 10 days or 15, the road width will not change. Today also my submission is, any moment.
What is the, as per your, what is the road width now?
Road width, 8.35.
More than 8.
More than 8. They assessed in 2009, his assessment, it should have been 8.5.
5.
Now, after assessing by the present committee, and this committee is under section 12, that committee is considering all proposals where the land area is more than 10 bighas. It is not for this specific project the committee was constituted.
Present route is 8.35.
8.34.
FIR is 275.
270.
Anything more than 8 can be 275.
275. Up to 15. And beyond 15, it is 300.
15 meters.
15 meters road. That's 6-lane roads on the national highways and all lordship. The whole idea of the central government has promoted this concept that there should be more people living in areas near the road. So the density of people living near the highways or the roads has to be increased so that there is less use of public.
Presently, if it's less than 8, it is how much? 200.
It will be 200.
8,
Up to 8, it is 200.
less than 8. 8 or
No, up to less than 8 also. Up to 8.
less than 8. And 8 to 15 is 8 to
101 maybe.
Lordship, this is the
10.
in the repetition it is there. Let us see the actual chart. Page 101.
Yes.
That chart is there.
Yes.
No, page 103. Existing road width, Lordship. Second column, the chart after the amendment.
Yes.
Up to 3.6, up to 4.5, FAR will be not applicable. It starts from above 8 up to 15 is 275. Up to above 6.6 to 8, 175. Depending upon the plot size also. Here, everything has to be, the plot size should be more than 10 bighas. Even if the road size is more, and if I do not have 10 bighas, I will not get 275. This is what I was submitting in the morning. Two conditions has to be fulfilled. The agreement says it is 13 bighas. In the morning, I placed that plot. So, above 8, up to 15 is 275, above 15 is 300. So, this is the new amendment. And it came, Lordship will kindly come to page number 99.
Yes.
Page 99, it was notified on 5th May 2020. So, he is right when he says that the present building permit, the planning permit and the building NOC is not conforming to 2014 bylaws. It is conforming to 2020 bylaws. Now reading further, because now they have again changing the goalpost. So last 3 lines of page 19, paragraph 20, in the process, apart from violation of its legal right. So Lordship, till now I could not understand what legal right has been violated. The other civil rights definitely has been violated, but that is not caused by the state or agencies or authorities. The petitioner has suffered serious prejudice and huge financial loss. Now coming to next page. Now the again contradiction. That at the same time the petitioner has agreed to the condition of non-applicability of extra FAR because the petitioner knew that the declared road width is 7.5 would not allow FAR beyond 2.
You are reading which paragraph?
Paragraph 21.
Yes.
Now he has come to his own sense. Now he is saying 7.5. This is a third stance. 8.5, 8, now 7.5. And little later in the reply, it will come to below 7 also. 6.34 or 6.57. Would not allow any FAR beyond. In fact, the petitioner was aware that the FAR could be reduced to 1.7 for all roads below 8.8 meters. So why he is fooling around this honorable court also as well as the authorities? If he knew that the road width is less than 8 meters, why all this tamasha? They are using the valuable time of this court and the agencies also, the authorities also. Just because he is not getting more FAR related share, now he is creating all this. Luckily, there is no stay order till now. This also became apparent during frequent discussion with architects, and the respondent number 2 was considering reducing FAR by road width below 8 meters to 1.75. So he wanted to reduce the FAR now by discussing with his architects. And these are on statements. Subsequently, the modified bylaw actually restricted FAR to 1.75 for road width below 8 meters. Therefore, the gross error made by respondent number 3 in stating that the road width was 8.35 meters and the respondent number 5 to take advantage of FAR of 275 ought to be set aside under this Honorable High Court's jurisdiction. It does not require any argument to establish the fact that the width of a road cannot be arbitrarily and manifestly expanded to give benefit to additional FAR to one party to complete prejudice to the other. So he thinks that it is flexible road. This is his indication here. If he is so serious about this particular paragraph, he himself took the NOC, he himself took the planning permit on the basis of 2 documents on the basis of 8.5 and 2 documents on the basis of 8. In 2009 and 10, it was on the basis of road width 8.5 meters. And in 2017 and 18, he took FAR 200 on the basis of the road width of 8. Now he says 1.75 could be the road width. That means he should first go to the jail.
7.5.
1.75. Sorry,
7.
below 7.
7.5.
7.5. These are on oath, Lordship. Are they making a child's play of all these things? These are perjury. Going to the next paragraph. That the petitioner respectfully begs to state that as far as the legal wrong which can be caused to the petitioners by entering into MOU on 9/11/2019 and the deed of on 6/6/2020, the petitioner will pursue his legal remedy in appropriate forum. However, the present petition has been instituted to redress the grievance arising out of the planning permit and NOC issued by GMD and GMC. What is evident from the facts narrated in the preceding paragraph is that the respondent number 5, in collusion with GMDA authorities, managed to get FAR of 2.75 when in law the entitlement is only 175 or at best 2. So he's flexible here now. He took 2, he took 175. So he is saying both now. This has become possible because so-and-so and so-and-so, which are partners of respondent number 5 partnership firm, are sons of so-and-so, who is the Minister of Housing, Urban Affairs and Irrigation and the Administrative Ministry of both GMD and GMC. It is the specific contention of the petitioner that it is a unique case where the minister has blatantly misused his position to do undue favor to respondent 5 for wrongful gains, where both his sons have decisive stake along with partner Manoj Kumar Jalan. It is worth mentioning that because of the enhanced FAR, the respondent 5 stands to gain approximately 2.5 lakh square feet of saleable area. When this enhanced FAR of 0.75 is computed in terms of money, it comes to approximately 150 crores. Therefore, what is evident is that in order to make windfall profit of 150 crores where everyone gets a piece of pie, the above illegality has been committed by the respondent authorities. Nothing more is required to show that the abuse of power by the executive at the behest of a minister, though Sri Ashok Singhal has not been arraigned as a party respondent, petitioner case. So when we objected, they made him a party. Now, pausing here for a moment, his whole case lies with the contention now in this paragraph is that this gentleman, Ashok Singhal, he is a minister. The building permission he obtained in 2009, 2010, 2017, 2018, and the other party in 2020. When this gentleman became minister, he became minister on 10th May 2021. So when this was coming to an affidavit that he became minister on 10th May 2021, they have shifted the goalpost again by saying that he is the chairman of GMDA. The submission made by my learned senior friend day before yesterday, he did not utter the word minister now. He is uttering the word chairman. Now, chairman of what? Chairman of GMDA. Who issued the NOC? GMC. He was a mayor MLA at that point of time. And his whole contention is that he is the minister of this urban development, that is Dohua or UDD till other day. So he is the minister of GMC and GMDA. His whole contention now. So he is not sure whether that person is chairman or minister, whether the road width is 8 meters or 7 meters or 6.5. He's confusing. He's giving all facts. So in that view of the matter, let him first get his facts corrected. And if the facts has to be corrected, the right forum is the civil court, not this court under Article 226. These are all factually disputed things he have noted in his pleading. Now, next paragraph is again interesting. That it is submitted, his submission, that the respondent number 5 is entitled to FAR 1.75 and not 2.75. Then how he got 2 in 2017 and 18? He got 2 on his application. He was not given 2. Then he came to this honorable court. This honorable court directed GMDA to reassess his proposals and his designs and drawings. And finally, 2 was given to him. Now he is saying respondent number 5 should get 1.75 or 2 and not 2.75. By granting FAR 2.75, the respondent have not only violated legal rights of the petitioner, but have also acted contrary to the relevant building bylaws, etc. So whether he gets 2.5 or 5 FAR, whatever, what legal right has been violated? His civil right can be violated.
What about the use of the logo?
I think McMullen is a big name at one. I don't know what Rochard they are saying. That is between them, and whatever I read in the morning, Lordship, that they can change the name of the project also. I do not know why they are with their logo. There must be a love affair between them. We are not into that. I will not say love affair, it's a love and hate affair. So going further now, paragraph 24. The petitioner respectfully begs to state that what is thought to be projected in the present case is an instance of blatant abuse of authority by the minister concerned. So they have not rectified it. So he was minister in 2021. And all these facts had taken place up to 2020 September. concerned to favor an entity where both his sons named above have stakes. The present case is not a PL but a petition filed by the petitioner for enforcement of his fundamental and legal right. What distinguishes a PL from an adversarial writ petition is that the rule of locus standi is relaxed in case of PL vis-a-vis writ petition, but both PL and an adversarial writ petition belongs to public law realm. Apart from personal legal injury, which has been caused to the petitioner by execution of MOU dated 9/11/2019 and deed of agreement dated 6/6/2020 with FIR 175, the petitioner is also highlighting the violation of the aforementioned building bylaws framed by the competent authority under the relevant head. So he has directly admitted that I have done a mistake by entering into these two agreements, MOU and the deed of agreement. In the deed of agreement also, which was, Lordship will kindly take the note down the date. MOU is of 9th November 2019, deed of agreement of 6th June 2020, and the law changed on 5/5/2020. So he missed the bus, he missed the opportunity. But for that, he cannot blame GMD or GMC. So it was a distress sale on his part. And maybe he knew that it has been changed on 5/5. In spite of that, maybe later on, somebody's advice may have come. Because I'll show some letters where the communication between the authorities and them is marked to some advocates when there was no litigation pending. So that is why some advice came. I can show it straight away, Lord. I'm not personal, but page 123. So Meghmola wrote to protect. There's the internal communication. The contents I will place later, but Lordship will see the copy mark to next page, page 123. So at that point of time, this repetition dates of 2023. So this letter is of October 2022. Several other letters are like that. So maybe he was fair. Maybe due to some external intervention, things have changed. I need not deliberate more on this. Now, coming back. Paragraph 27. That from the above facts clearly points out that the petitioner has a strong prima facie case in the present case and the balance of convenience also lies in his favor. The petitioner will suffer irreparable harm if the Honorable Court does not declare extra FIR granted to respondent number 5 by the respondent of number 1 and 2 as illegal and contrary to applicable laws. So according to him, he should get 175. He himself got 2. So if Lordship will have to interfere, because there is a direct prayer on that. Page 25, prayer number 2. Certiorari sitting aside and quashing the decision of the respondent authorities to grant FIR 275 to the instead of FIR 175. When he himself was enjoying 200. Only because of clause number 15 in the MOU, all these things have happened. This letter also is the indication.
And so far as the first prayer is concerned, at page 24.
I have not gone to paragraph 4.
No, page 24. First prayer.
First prayer, Lordship.
Page 24.
Yes. That
you have already made your submission that you are agreeable for a commission, even assuming that
whether that is required or not.
On the width of the road, they said that they want interference with the GMTA permit as well as the GMC permission only to the extent the road width has been wrongly taken as 8.35. You said that even if the commission is made, this can be factually be ascertained.
Lordship, we have already done it. I have the report. I have not placed it. After Lordship going through that report and all my submission, still Lordship that there should be a commission, I agree to that. But whether that is necessary, because this is not a fact-finding court. There is Supreme Court judgment of 2015 that these commissions and these things are not necessary when there is a dispute regarding factual aspect. If at all they want that the road width is different, the right forum will be a civil court. Now the other case is Green Village case. This honorable court directed one of our very respectable advocate go and give us a report. That report is given. Today, my learned senior friend AC Borbora's client filed the objection. That will demoralize our commission, the advocate. Why we should subject them to this kind of humiliation?
Commission report are only the form of an evidence. They can
Evidence,
be
absolutely.
subjected
Now,
to,
when that evidence is not believed, now tomorrow this comes as 8.34. Suppose any XYZ goes there.
it will not be a discouragement. Even judgments are put to appeal. It will be a discouragement for,
What I am
for the
saying,
judge if
Lordship,
the-
what I am saying, my submission is different because that particular commission is not a party here. I'm not about the judicial officers like Lordship. At least there will be something on record against Mr. Rishikesh Sharma now. I have not gone through it,
nothing
but
like
that is where the
Nothing like
Supreme
that.
Court deprecated them.
It's part of the system. But you can argue that it all depends on the facts and circumstances. Why at
Exactly.
the instance of the
Exactly.
petitioner,
Now here,
who
that
is
is-
only for a share of his amount?
absolutely, Lordship. Now the thing is very clear. We have done it. On paper, we have given it. Whether we have done it yesterday and just to, because I took 1 day's time only for that purpose. Whatever I will make submission, it should be correct. It has come to be on dot correct. Same thing has come out. If Lordship, after hearing us, gives that direction, I have absolutely no objection to that. But Lordship will have to first give me that opportunity to place whether that is necessary or not. It's a matter,
But,
and on top of that,
but the-
everything, Lordship.
but the purpose of us, so far as prayer number 1 is concerned, that this is factually not correct. As per the first prayer that they want to offer the permission of the bank
Yes,
on the basis that 0.35 is not width of the road. That even that is not correct. As per it is 8.35.
35. 8.34.
But anything above 8 is
Absolutely, they're irrelevant, immaterial, up to 14.99,
up to 15.
up to 15, sorry. It is irrelevant. And he himself got it on the proposed road width of 8.5.
8.5.
So he knew it very well. Why he is objecting now? He reaped the benefit. He also sold some of the flats.
And you have also submitted that it is the relevant is the Tarun Nagar lane, not the Anil Nagar lane.
No.
And if Tarun Nagar is taken, it is 8.34, which what you are saying.
Lordship. And that was on the
Understood.
ground when it was considered to be 8.5 on the pretext, on the ground that a bridge will be constructed there. So that the wider road on the other side of the river of the project is wider. That is as simple as that. And the average road, the first point, the maximum, the minimum, and the land or the road in front of the project. These are the 3 areas from where we have to measure.
Where is that map which was
Page 97.
Page 97, self-made map.
that means this road of Tarun Nagar, which has been shown as 4.5, that's not be relevant.
I
Because
do
that
not
is
know what is the basis.
No, no,
They have
even-
only said the 12 meters frontage area. That
No, no,
12
um,
meters,
Mr. Sekhya, in this, they have shown 2 roads. One going from left to right, that is the Anil
yes,
Nagar road,
yes,
which shown as 4.5 meters.
that is not considered.
Yes, and the other is the one black portion, which is the bridge,
Yes,
and Tarun Nagar by that, which is
7.5.
7.5 meters.
7.5.
So for, you say that for all practical purposes, this 4.5 meter wide road from Anil Nagar is not relevant at all.
Absolutely not relevant for
What is
calculation.
relevant is the Torun Nagar.
Torun Nagar Road.
And that
bilateral
also they proposed, which was 8.5 on the strength of which he was given the permission.
2009 and
9.
10.
And that as on now is 8.3.
8.3.
So it is more, it can be 2.275 can be.
And this 21-story building that has no legs to stand, because at that point of not a single pillar was erected.
Foundation was not there for 4.
That is their
and
own
fi-
record.
5 is a new thing.
I do not know what they will submit, but from their record, it is very clear that the work
What
is
about the other 1, 2, 3 blocks?
1 to 3 blocks, Lordship. He himself started with 9th floor, 8th floor, then he got up to 14th floor because he got enhanced FIR in 2017-18. And what I have heard, because it will have to come from their mouth, that in one of the building there were 900 piles. They have added another 600 to make it 15. And all these things, Lordship, the occupancy certificate, completion certificate, everything, and
Where is the new certificate now? Where is the new permission now?
new permission they have annexed, Lordship. It is, yes, that I would like to read out. 88.
88.
The impugned one. Very interesting, Lordship, here. The remarks part also, Lordship will have. May I read it?
Yes, sir.
10 September 20. This is the planning permit at the top.
Yes.
So planning permit has to be given by GMDA and the NOC has to be given by GMP.
Yes, yes.
Application dated 1/9/2020 submitted. So on 1st, they have submitted and we have given it on 10th. So exactly 10 days we have taken. So there is no rush here. In fact, our officers should be given credit that because of the holidays also, they work and submitted it on time as per the statute.
Then what?
With reference to the above application for development or re-erect, etc., village so-and-so under Section 5, read with Section 4 of the Guwahati Building Construction Regulation Act 2010, in accordance with plans submitted with or without modification condition. The proposed area for construction falls in residential zone as per master plan. The particulars of the construction for which the permission accorded is given below. Modification in the building plan, if required, shall be done within the permissible limit. Here, Moja so-and-so, right-hand side, 8.35 meters average, 4.67 meters, 5 meters wide, existing road. Name of the road is also there. Then coming to FAR, serial number 2. FAR, base so-and-so, residential apartment 2.75, residential apartment 2.7 so-and-so. 2.75 it has been given. Now the remarks part. Clearance of MOEF, Assam State Groundwater Authorities, suggestions from FPSA, proof checking of detailed structural drawing designed by SDRF are to be obtained prior to commencement of the construction. So SDRP's role is also there. Other provisions of 20%, etc., to be kept exclusively for open space, etc. B. This planning permission is issued by cancelling the earlier NOC dated 3/11/2018, which he obtained. So it is not transferred. His was cancelled and a phase 1 was issued in the name of the new entity. Then next page. The proposal shall be governed by the provisions of Real Estate Regulation Development Authority, etc. The planning permit is issued on the basis of recommendation of the 3 members committee constituted by so-and-so, so-and-so, dated so-and-so. Now let us read this committee's report in our affidavit. 188. I will place my affidavit at the last slot, but this report let us go.
So you want to have a number of floors.
Number of floors.
Floor A is, first block is
Two floors have 21, rest are less, Lord.
Let's 11 and 10.
Yes, two have 21.
Yes.
And rest have 14 and 12 like that. Yeah, at page
Page 88 itself,
page 88.
number of floors, the second,
Lordship will kindly come to page 93. The GMC's NOC. The final one. 99 issued by the Guwahati Municipal Corporation.
93. 93.
Page 93. Number of floors on the right hand column, Lordship.
Yes, number of floors.
LG plus 11, LG plus 10, LG plus 21, LG plus 21, LG plus 19. So 5 blocks. It is not 19, maybe it is 13, I think. So the FAR is accommodated in 5 blocks.
You may be correct. 13.
It is 13.
Was down 30. And E, you have said that it is not even a new thing altogether.
It's a new thing.
D was not, condition even was not done.
This is their record, Lordship.
Their record.
Their records.
And C, you have said that in the enhanced permission, it was increased to 15.
Yes.
And now, by the present permission, it went to 21. And so far as A and B are concerned, which were already constructed, has restricted to 11 and 10.
Lord. And 600 additional files were added. I am repeating, Lordship, nobody will take that risk of having a building with less strength of foundation, having more stories. Everybody will go en masse to the jail, from the architect to the planner, everybody. And Lordship will kindly see the road, name of the road, it is not mentioned, right, left hand side, 4 columns from below,
Name of the road.
8.35.
Yes.
8.35 average, then another road is 4.67 meters, and then another behind one, 5 meters, while existing road. These are all now in existence, not proposed. And next page, Lordship will kindly come to page 94. When GMC issued it, certain conditions were given. This permit shall remain valid for 2 years from the date of issue of the permit. Permit is not transferable. The commencement of work, etc. Condition number 1, MS Creations Ulubari, along with the builder, will be held responsible for any kind of structural failure of the building. NOC from Director of Fire is to be obtained. Necessary firefighting, etc. Groundwater, etc. Number 10. Owners to the licensed architect, engineer, as the case may be, who has supervised the construction shall give notice to the authority regarding completion of work and obtain occupancy certificate before occupying the building. The building above 7-story party shall submit detailed structural design for proof checking by SDRP at least 1 month prior to commencement of the construction. So all these cannot be bypassed. And occupancy certificate, there is a provision. They will give the completion certificate. And once the completion certificate is given, then there will be inspection. And finally, the occupancy certificate is issued. And while issuing this, all these documents issued by SDRP, etc., have to be verified. The project is going on. It is not in the completion stage. And next page, the details of the up to 24 floors are given, page 95. One document issued by him at page 118 of the report.
118.
Yes, 118. This is issued by Anup Toike. I think he is the chairman of the Petitioners Company. He wrote to Manoj Jalan, Tote, 19/10/2021. regarding eligibility of claiming FAR of 275 based on ground realities as amplified by the reports enclosed under reference below and contents mentioned in the body of the letter stated. He has given some report. This has reference to the above. In this connection, I'd like to impress upon you that the FAR 275 which you have obtained goes against the spirit of legitimate approval process. My statement is based on the following facts. Kindly refer to page 2 of the report annexure 2 and I have highlighted the relevant portion in green for your convenience. As per report, the Tarunnagar byline number 2 is the wider of the two roads leading to the project site. As such, while existing bylaws 2014 clause 24, this road and its calculated average width of 7.5 should be considered as legitimate FAR. So he also states what I am emphasizing is Tarunnagar lane number 2. The applicable FAR for Tarunnagar project as per existing bylaws should be 1.75 and not 2.75, whereas he himself obtained 2. Now coming to the next page. Your attempt to claim benefit by shifting the boundary wall in the adjacent road which do not form a part of the relevant provision of FAR calculation tantamount to suppression of fact to the authority to gain undue advantage. As per the inquiry report at annexure 3 at page 4, highlighted in green and quoted below for convenience of reading. This report, I do not know what report they are saying, but it has very important relevance. Missing link between the road developed by PWD roads into the bridge point with a minimum of 4.5 meters, which should be constructed by the developer at their own cost. These are all of 2013. If required by relinquishing land from the owner's plot for making the road accessible to the public. So who gave up that land? He constructed this morning. My learned senior friend Chaudhary very proudly said, my client has constructed. This report says if required, relinquishment of land is required for public. That 4 meters road which has been relinquished, it is not by the Protect Group. It is by the Meghmalar Group. And it has become a public property. And when this inspection was done by this committee in 2020, they have found a boundary wall. There is a boundary wall with 12 meters, 12.5 meters width road. Today, for the sake of getting more FAR or additional FAR, it has not been put behind. It was put behind at the time of getting permission to construct the bridge. And this is their document. This is not my document. Government's document, no. These are private communication. And this Anup Saikia, they have annexed it before this honorable court on oath. So, if required by relinquishing land from their own plot for making the bridge accessible to the public, there is a big story why there was objection to the construction of bridge. The Deputy Commissioner Agnihotri stopped it. 2 years later, after revisiting all the authorities' opinion, then it was granted. One of the conditions is that the land was not sufficient in front. There is difficulty in accessing the bridge, the turning and all everything. Traffic police opinion was also taken. Then it was finally considered that the road has to be wider. And if Lordship looks at the map, the sketch I have given, the bridge is just in the middle of the project, where the road width is 12.4 meters. So who gave up the land? And there is provision of additional FAR. Of course, that provision was never relied upon anybody. There is provision under the bylaws that if I want to enhance my FAR, if I give up land for public use for expansion of road, that is permissible. So what he has done, it is permissible. That giving up or relinquishing 4 meters of land. But that was done, that relinquishment of land is not to get additional FAR. That relinquishment of land was done to get the bridge constructed. The objective is different. Indirectly, it helped him to get more FAR. Indirectly. And that benefit he took. Not the new entity has taken this benefit. So the bridge is just at the middle of the project. So now, very interestingly, few lines more also I'd like to read out. if required by relinquishing land from their own plot for making the bridge accessible to the public. Going by the extract of the report, it is apparent that no road existed up to the bridge at the point of Anil Nagar site. How can one make a claim of extra FAR by shifting the boundary wall and showing a wide road in front of the complex? Assuming the road exists now, then the portion of the road is dead end and the dead end, etc. That is not relevant. Now coming to the last 3 paragraphs. I once again impress upon you to consider the issues I have raised in my earlier communications and the discussion we had in my chamber on 18 October 2020. So after that MOU and deed of agreement also some negotiations was going on. This is indicated. What issues? More shares. That is the only thing any prudent man can guess. In the great till that the writ petition was not there. This writ petition in my humble submission is filed with an ulterior motive. And with full responsibility I am submitting. In the greater interest of the project, please ensure that the goodwill that existed earlier to your issues of the caveat, if restarted as soon as possible, I will endeavor to reprocure the same. I will hold this communication in the strictest of confidentiality and make sure that it is not exposed to the unwanted interference by any third party. I hope you will do the same. Lot of meaning can be given to it. Why I am placing this? That they are trying to use this honorable court also for their bargaining process. Yours sincerely, Anup Sai. And I have already shown paragraph 120, page 123. Interference of advocates are already there. It is not illegal. But why I am trying to say that this is not regular, this is not normal. Another letter at page 124. Request for information. Third paragraph on what? I can read the whole. The authority will clearly recall the Magmolar flagship project under the name and style of City Center Residency at Torunnagar was called for years because of public opposition raised under the banner of Torunnagar Unnayan Committee. Magmolar had all the necessary permissions from all the authorities to proceed with the project, but could not proceed because of the public opposition to the project. A protected legal battle had ensued, and during the proceedings, Guwahati Metropolitan Development Authority had to submit relevant documents to the High Court, justifying why the project had got the legitimate approval of the construction of the project. The question was why that 8.5 proposed road was considered while giving the affair. That was the core issue. In this connection, I would like to inform you that TMDA had submitted to the High Court a brief report to the point raised during the hearing on 23/12/2013 in connection with WPC so-and-so, dated 4/12/2013 of Magmolar State and Services Private Limited at Torunnagar, Bailand. Copy of the said report is enclosed and marked as Annexure 1. The said report certifies Torunnagar, Bailand number 2 have the average width of 7.5 meters. So on that day, it was 7.5 correct plot. Bridge was not constructed. Subsequently, the High Court ruled in favor of Magmolar and the project was restarted with renewed permission from all the concerned authorities. This line I am trying to emphasize because his own contention that High Court found the permissions are validly given. That means 8.5 meters road, proposed road can be taken into consideration. For that, I would like to place the definition of road. The definition of road, Lordship will find it in the building bylaws of 2006 onward. The definition has not changed. Building bylaws 2006, road is defined at 2.52. Definition 2.5. on the top plot, page 273, Lordship is the same. Definition 2.52. If Lordship is taking the same book, then it is 272.
Of the bylaws of
Bylaws of 2006. Because the permit and the permission was of 2008 and 9 and 10.
which is the page?
Page 272. Road means and includes any highway, street lane, pathway, alley, passageway, carriageway, footway, square bridge, whether private or public, whether thoroughfare or not, whether existing or proposed. So proposed is also to be considered. So when he took that permission with proposed width of 8.5, there is no illegality or infirmity on the behalf of GMDA to give that permission. So proposed was correct. In any scheme activities, Deputy Commissioner in 2013, Agnihotri said that existing road should be considered not proposed. On that ground, the bridge was not permitted. So when the definition says this is a statutory law, so we have to consider every word and we have to give the actual literal meaning unless there is any ambiguity, where this law honorable court will give the meaning. But when there is no ambiguity regarding the meaning here, the language is plain and simple. Any layman can understand what is a proposed road. So the proposed road of 8.5 was correctly done at that point of time. But now, Anup Saikia writes that it should be 7.5. Of course, 7.5 was also correct. That is also correct in 2013, the report of the existing road, not of the proposed road. The proposed road average width got enhanced in 2017 with completion of the bridge in 2016. The said report certifies Torunnagar byline number 2 to have an average width of 7.5. Report is of 2013. Subsequently, the High Court ruled in favor of Meghmallar and the project restarted with renewed permission. Unfortunately, Meghmallar could not continue with the project and the project was taken over by Protect Housing Group, redesigned the project and secured press permission from all the authorities to relaunch the project under its own banner as Protect Torunnagar. However, when Meghmallar reviewed the permission received by Protect Housing, it has revealed some gross irregularities. The primary irregularity relates to GMDA declaring the road width of Torunnagar byline number 2 to be 8.35. This declaration has entailed Protect Housing to become eligible to claim 2.75. It is surprising that the authority is contradicting its own report submitted to the High Court as detailed above. So my humble submission is that what they have stated is that according to them, the road width cannot become dynamic. Lordship remember 20 years ago, what was the width of GS? Now it is 6 lane. At one point there was single lane. If Lordship goes back to 30 years ago, we see only one bus. So it is a dynamic situation. So it cannot be said that the road width will remain static throughout. Saraighat Bridge, earlier there were 2 lanes. Now we have 3 lanes here, 2 lanes here, 8 lanes road now. 2 bridges together. So these are dynamic concepts. So what was there in 2010, 2013 and 2016, totally different. Law has also changed. Law of 2006, 2014 was amended in 2020. And that is precisely the reason why the Protect group got 275, whereas the Meghmallar group got 175 in 2009 and 10, and in 17 and 18, 200. This is because of the changing circumstances. If I may stop to the Lordship. I will go to their reply next.
You have some other work.
No, I have a lot. I think another 2 hours I will require because I have to give a clear picture. I have a meeting at 4 o'clock. I did not thought that it will continue up to this.
But-
I'll continue with the reply from tomorrow.
Mr. Das,
No, but going through it, I got all this contention, my attachment has raised. But absolutely, I will argue on the locus. And I have been doing unnecessary 1596. All
Will-
15
Now, first you have to decide whether he is chairman or he is minister.
but we like to see Mr. Das in the group. Why are you saying unnecessary?
Except me, all are enjoying lot. Both sides. Yes, both.
You like to,
Only what I just made a prayer, my lord. Your lordship's prayer.
no, when did you like to make this up? After,
After Mr.
Complete-
Pathak's over, then I will make it up.
I can continue tomorrow if lordship permit.
Can it be
tomorrow
on,
Friday,
No difficulty.
Only
Lordship, let it be on Wednesday, lordship.
on 30th is better.
Wednesday, there is a Tuesday, there is a game in Guwahati, lordship.
38. Let's put 38.
30th.
38, your lordship, I just.
In fact, I'll need another 2 hours. Lord.
30th,
Games village is there, but that will not take that kind of time.
38. 38.
30th. I think,
Our reply will come after at the end of all.
whatever, 30th.
Yes.
If lordship permits, I can give you a written submission or
After
whatever
after completion.
after completion. Deeply up.
If you-
Okay, we'll have it 30th.
Hello,
I will only request the second
lordship.
that since you have read to a number of pages, but
That is why I will give a
the
written.
pages which you have referred are not many, around 10 or 14,
Lord.
15 pages. You can just separately take out those pages and give it in a bunch so that we
Okay,
don't need.
Fine, Lord.
This,
In fact, one of
actually,
my colleagues, she is there noting down which I
this
am.
file is very bulky.
Yes, lordship. I'll do that. Highly obliged.
With the same page marking.
Exactly, lordship. We are in whatever way I have submitted
Yes, yes.
in chronological order.
Take the date, lordship.
We could have disposed this of.
Yes, lordship.
What was it? Your senior has
Yeah, lordship,
Mr. Talukdar has said something.
I will have the late here, Lord, if the court reports.
Let it fix it, there, your lordship.
No, it would hold hearing has been against the redundancy account as complete and put the secular started and the same remain in conflict. This court participation. No, not your case. Where is Madam Tekaraja?
I'm for 11.
This was
Yeah, 12. Respond. I'm for response.
no. That Mr. Kent, Advocate General's matter we had. did it,
we
yes.
had
30th.
not your
Yes. We can dispose this of perhaps.
Yes, they've informed me that instructions have come.
Yes. as per which they do not have any,
Yes.
officially they do not have any third wires conducted song for BJ Talukar Senior Council for the response number for official respondents. For the superintendent of Golaghat.
Your Lordship. That's number 3, Your Lordship.
Rest we have already taken steps, but they have not appeared. That's your talk.
As regards the rest of the respondents, this court by order in 310 had recorded that service upon the state respondent is complete. The fact projected by the petition is that he is the, please have your, he is the owner of a plot of land measuring 1 Katha 10 acres in ward number 13 of Golaghat. In order to construct a G+2 arts building, the petitioner had applied for permission to the Golaghat Municipal Board. The pursuant that in the case of the petitioner, that pursuant that such permission was granted on 7th Street 2020. The petitioner has relied upon a notification dated 24/9/2020 of the Ministry of Jal Shakti that individual domestic consumers are exempted from the NOC for groundwater extraction. The demand of the petitioner is, however, against the respondent number 4, who is a ward commissioner, along with certain individuals who had trespassed to the land of the petitioner and stopped the boarding of the tube well. The petitioner had also approached concerned police authority, namely the Golaghat PS, even whereafter there is no action, and therefore the petitioner has approached the Manna Zealand Council for the has submitted that the action of the private respondent of court, along with some persons brought by are not backed by the authority of law. He submits that so far as the construction is concerned, due permission has been taken, and so far as the tube well is concerned, requirement of any NOC for domestic use is exempt, and therefore, even otherwise, there is no violation of any nature by the petitioner who are the construction in question, including the boring of the tube. The alluder to London Cine Council appearing for one of the however submit that as per instruction, there is no official objection either regarding construction question or boarding of the tube, and therefore the allegation of the petition cannot be made against any of the officials. The Senior Council, however, fairly submit that the allegation made towards the husband of court would be in her personal capacity as being a ward commissioner. The state husband of court would not have the authority in law to make any obstruction of this. After hearing the counsel for the party and upon consideration of facts and circumstances, it is disposed of by direct the respondent, namely the respondent was one to ensure that there is no unauthorized obstruction on the petitioner in boarding of the tube or any part of the construction which has been done after following the law. Holding the petition according to
Much obliged.